my beautiful friends. What an amazing day it is. Welcome back. I hope your week is unfolding oh so beautifully well. We have an amazing stream planned ahead. Lots of documents dropped today, fresh out of the oven. We've got over 200 pages to get through, and they are going to be delicious. So thank you for being here and joining us. Quick preview on what's coming up, then we'll zoom in because we got some docs to review. Now, we're going to talk today, starting off, about Trump's appeal in the Alvin Bragg, Judge Juan the Con Mercan case. Remember this one we covered some time ago. That was a fully rigged trial that had people like this person over here as witnesses. Remember, we had these individuals, Michael Cohen and Stormy Daniels, along with David Pecker and the rest of them. And they were very, I would call it fraudulent in their jury instructions and in their creation of the prosecution against the president. We had a convicted perjurer, Michael Cohen, come in saying that he was the person who ultimately paid off Stormy Daniels and said that in writing multiple times. Remember, we heard from his former lawyer, Robert Costello, who had a waiver of privilege and all the things. We're going to come back to that, but we got the appeal that has now dropped on that. Remember, 34 felony convictions that they rigged through the state statutes to bypass the statute of limitations so they could bring the charges against him. Well, now the appeal is working its way up, and it's a big one. 111 pages right here. We're going to go through it and hit all the details because we have been waiting for this one. All that coming up. Then another major drop today, which came from the Oversight Committee, and they're now saying today that the Biden pardons are, look at this, null and void. Not all of them, but many of them. And we'll go into details on their new report. You can see they dropped this puppy also out today. 100 pages, the Biden auto pen presidency, decline, delusion, and deception. And damn good alliteration too. So that's coming out of the White House. We'll read through the details. Lots of reaction on this. The Oversight Committee and Congress releasing video footage from the depositions. And so we are jamming. This dude has a real hard time admitting how much his bonus was if Joe Biden was going to win, obviously leading to a pretty questionable conflict of interest if these guys have to rig the news so they can get paid their millions of dollars. So we got a great stream ahead. And my friends, very glad that you're here and with us. Thank you for joining us as a membo. We have members only streams in the mornings. We have after parties. We deliver as best we can for our membos because we love our membos. And we'd love to have you come join us. If you want to join us on the after party, stick around. We'll be doing that today. You can join at watchingthewatchers.locals.com or on YouTube, and it will auto transition us to the members only after party, which is where we'll debrief what we talked about today and have some more fun. So come and join us, and we're looking forward to seeing you there. We also now have fresh documents to get to, and we are excited about where this one is going. President Trump appeals his criminal convictions. You remember this case that came from Alvin Bragg and the quote, the people of the state of New York. Remember, this is the land of Tishy Latish James and Alvin Bragg and Juan the Con Mercan and Matthew Colangelo, who came from the Biden administration to go help facilitate all of the lawfare attacks against the president. And we saw the convictions. We covered the entire trial. We had a beautiful mind map where we got to assemble all of the pieces here. But remember, this was the guy who brought it. Alvin Bragg is the DA out there in Manhattan, and he brought the case in front of Judge Juan the Con Mercan's courtroom. Now, remember, the judge had a bunch of conflicts of interest with his daughter, who was raising money for Democrats and spending money on Democrat campaigns, writing ads for Adam Schiff on Facebook to raise money for him that said, Trump just got indicted and Trump just got arraigned and had his first court date where? Her dad's courtroom. Remember that? So then Trump, as we recall, he brought in his defense attorneys and they gagged Trump. Remember this? They actually gagged him, said he can't even talk about the judge's daughter and any political corruption or conflicts of interest that existed. And Todd Blanche was one of the dudes who was representing President Trump at the time. Got a bunch of information on this mind map. You can see some overlapping happening right now. But all of this was predicated on these two horrific witnesses. Michael Cohen, a convicted perjurer, as we already saw, for lying to Robert Mueller, lying to Congress. And his own attorney said that Michael Cohen confirmed to him that he was responsible for the payments over to Stormy Daniels. And Stormy Daniels came out in the trial, and she had some of the weirdest testimony of suddenly it transitioned from like a consensual affair and intercourse into this entire brutal virtual rape, essentially, from Stormy Daniels. Total liar, in my opinion, as well. Because remember, Stormy Daniels also said multiple times that there was no affair. Remember, she posted this on her account where she said, you know, I've been asked many times whether there was an alleged relationship with Trump. But the fact of the matter is, there is no relationship. I am not denying this affair because I was paid hush money. I am denying the affair because it never happened. I will have no further comment on this matter. And the case, of course, proceeded forward because they wanted to get Trump convicted and maybe even in prison if they could get to it. But they lost, and President Trump won the election. And now we're going up on appeal. And with all of that background, let's get right to it. Trump's appeal making its way into the New York Supreme Court, the appellate division, in the case of the people of the state of New York against Donald Trump. Again, this case brought by Alvin Bragg. And now Trump's attorneys are representing him here: Jeffrey Wall, Morgan Ratner, and many others. And here's where this begins. Once we fast forward through the table of contents, we'll see here they start very clearly with an opening that sounds just like this. All right, Court of Appeals. This is the most politically charged prosecution in our nation's history. After years of fruitless investigation into a decade-old baseless allegation and under immense political pressure to criminally charge Trump for something, anything in italics, Alvin Bragg, the New York DA, he manufactured felony charges against a once former and now sitting president. And when you come after the king, you best not miss. The DA, a Democrat called Alvin, brought those charges in the middle of a contentious presidential election when Trump was the leading Republican candidate. These charges against Trump were as unprecedented as their political context, targeting alleged conduct that has never been found to violate any New York law. Alvin Bragg, he concocted a purported felony by stacking time-barred misdemeanors, remember? And the jurors could just pick a card, any card. Well, pick any misdemeanor you want, under some convoluted legal theory, which Alvin then improperly obscured until the charge conference. Didn't even know what the theory of the case was until we got to the end. This case should have never even seen the inside of a courtroom, let alone resulted in a conviction. And so this court, the Court of Appeals, should now reverse. Federal law preempts this misdemeanor turned felony charges because those charges rest on campaign finance regulations that the feds have jurisdiction over, not the states. The trial conducted by Alvin and Mercan was fatally marred. They introduced official presidential acts. The Supreme Court said you can't use that stuff as evidence against the president. He's immune. He's allowed to do those things because he's the president. So you don't get to use that against him as evidence if he's allowed to do it. The jury was instructed incorrectly by Judge Juan the Khan, allowing a conviction without the unanimity. Again, the jurors could just kind of disagree as to the key elements in order to secure a conviction. Totally ridiculous. New York law requires that. Basic due process does as well. Beyond these flaws, which are fatal, the evidence was clearly insufficient to even convict Trump. Now, in addition to all this overwhelming error, this judge also should have recused himself, and he refused to do that, despite having made literal political contributions to President Trump's electoral opponents, donated to Democrats and Joe Biden, and then sat there and convicted Trump. And despite having disqualifying family conflicts with his Democrat hack daughter. For each of these independent reasons, Trump's conviction must be set aside. That's a banger of an opener right there. Lots of problems, as we can see. Let's dive in. First, Federal law expressly preempts Alvin. Federal law already criminalizes it, and he's trying to subsume their powers and create state charges there. His theory was that Trump somehow violated these New York statutes. Remember these various laws, penal law and election law, by engaging in or concealing a conspiracy to make contributions that violated federal law. So he's saying you committed a state crime because you tried to sneak around federal law. But federal prosecutors already investigated that. They took no action against President Trump even after he left office in 2021. So Alvin is predicating the state violations on Trump usurping federal law. Federal law was already investigated. There was no violation of federal law. So what is he basing it on? That should have barred any prosecution because the federal law has a sweeping preemption provision saying we handle these cases, not the states. It says explicitly, the provisions of this act supersede and preempt any provision of state law with respect to federal office. Oh, U.S. code right there. Congress directed wisely that only the federal government, not thousands of local hack prosecutors, enforce this. It's complex. It's politically sensitive, and you let us handle it. That's in the law. Now, when Trump raised preemption, when he said, you can't charge me, this is a federal offense, they've already been investigated and nothing happened. Alvin Bragg claimed, well, our theory is not limited to violations of those two provisions, and that its case would stand up even if you take that out of the picture. Okay, so as we get started, he's like, nuh-uh. That's not what I'm using to prosecute you. Can you tell me what? No. Judge, can you make him tell me what they're using to prosecute us? No. But the theory that Alvin Bragg later put to the jury actually relied exclusively on that specifically. And they asked the jury to improperly convict the president based on a violation of federal law in state court. Because Alvin and his effort to twist New York law to duplicate the federal law's restrictions, it's preempted and it's barred. And so this court must reverse that. That's just point one. Now, as to two, the trial court also violated the presidential evidentiary immunity. We covered this in all of the other prosecutions. Hack prosecutor Jack Smith prosecuted Trump in Florida and D.C. The D.C. case went up to the Supreme Court. They said, oh, yeah, the president has immunity, even though they told us he didn't for as long as possible. Judges have immunity, Congress has immunity, but the president, for some reason, has zero immunity, even for doing things that are within the confines of the presidential prerogatives and power constitutionally delegated to that person. Insane. But that didn't stop Merchan. It bars the use of evidence about the president's official acts. Supreme Court said that. They didn't care. The jury improperly heard extensive testimony. And remember, Trump, during the Judge Chutkan January 6th case in Washington, D.C., they said, Judge, you have to pause the case while we question presidential immunity. She did not want to do that, but she was forced to. And then Jack Smith kept filing motions, we're going to keep prosecuting. No, he had to stop too. Trump said, stop Jack Smith right there. Chutkan said, I don't want to. Do it. You have to. She's fine. And she did. So Merchan could have done the same thing, could have paused the case, fleshed out these immunity issues, going up the Supreme Court of New York, up and down, all things, and resolved that. But they didn't, because their end game was to convict Trump. They wanted a bunch of people like Adam Kinzinger to run around and say, 34 felony convictions. What was the penalty for that? Oh, nothing. A suspended sentence. He didn't get jailed, no fine, no probation, nothing, because he won. And now they're saying that the jury didn't get that opportunity. They had to weigh all of the evidence that should have been paused and postponed. They also heard 4 different kinds of official acts by Trump. 1, they heard all about discussions between the president and the White House comms director, who I think was Hope Hicks at the time, over the White House response to allegations of wrongdoing. White House has a comms division to field questions from the media. Trump's allowed to talk to her about responses in the media. There was also official presidential statements on social media. He posted it. The judge said, well, I don't really think that's a presidential post. It doesn't matter. He's the president, and he posted it. It's an official correspondence. Read it and weep. Alleged discussions, again, between the president and the attorney general about campaign finance regulations. He's allowed to talk to his AG, and Trump's practices in discharging the presidential duties. And remember, they brought in I think Madeleine Westerhout was the other one, who was like an assistant to Trump, asking him about his phone calls, asking him about his wife, saying what happened in the Situation Room. All of the inner workings of the White House, which are all immunized from criminal conduct if they're within the bounds of the presidency, and they clearly are. Now, in Trump, the Supreme Court case, remember we covered this one, the Supreme Court mandated that violations of presidential evidentiary immunity, if you violate this, it requires an automatic reversal of that conviction without any harmless error analysis. So you don't get to say, oh, well, we screwed up on your immunity. Oops, sorry about that. But it didn't matter to the jury. And the jury can still come to a proper conclusion even without that evidence. And they say, can't do that. Sorry. The violation is sufficient enough that the sanction is dismissal. Charge is gone. Even if that analysis were applied, Alvin Bragg's a liar. Repeatedly relied on and called devastating all of this action that was official and protected in its closing arguments. And that was far from harmless beyond a reasonable doubt. Even if we have to use that test, we're still going to win. And third, Judge Juan, the Khan, Merkhan, he also erred. He instructed the jury that it could convict Trump of, quote, having conspired to promote or prevent the election of any person to a public office by unlawful means. And we were asking this the whole time. What does unlawful means actually mean? What is that definition under the law? And the judge allowed the jurors to decide whatever they wanted it to mean. No requirement that the jury was actually unanimous on that key element of the statute. And they could pick a card, any card, if they just decided whatever. That was good enough. Instead, the court permitted the jury to convict if some jurors believed only that Trump had conspired to violate the federal law. Others believed, well, maybe he did what he did to commit tax fraud. Another card. Oh, I like that one better. Still another believed that only if he made false statements to a bank, then that's sufficient. And they could pick whatever they wanted. As long, the judge said, as long as it said, those are all unlawful means. If they believe it's an unlawful mean, that checks the box. Obviously ridiculous. The due process and the law don't permit a conviction based on such a haphazard combination of jury findings. We need unanimity to talk about the conduct. And you got to prove that conduct beyond a reasonable doubt. Beyond a reasonable doubt. If they can't even agree on what the underlying conduct was that is actually criminal, isn't that a pretty good indicator that there's not agreement there beyond a reasonable doubt? Otherwise, they'd all agree with the one. New York Constitution even supports that. And fourth, Alvin Bragg had no proof that Trump ever had any intent to defraud. It is expressly required under New York law. In fact, at the trial, there was zero evidence that Trump intended to deprive anyone of money or property. And in fact, there was no deprivation at all. Having no other choice, Alvin rigged it. He advanced a flawed theory. And the trial court stamped it, saying that, well, intent to defraud, just like the other unlawful means provision, it can include whatever you want. It can include intent to interfere with unspecified government regulators, or it could be intent to deceive the voting public. Now, making those matters even worse, Alvin Bragg did not prove that Trump acted with either of those intentions in mind. And the judge just let the case go to the jury. And finally, this judge, Judge Juan the Khan Merkhan, seen here in this photograph right here, he failed to properly recuse himself, erred in doing so. This was a uniquely political case, and the New York rules of judicial conduct, they require that, quote, a judge shall, not may, shall, it's mandatory, disqualify himself in a proceeding in which the judge's impartiality might reasonably be questioned. And boy, was it. By any measure, this judge's impartiality was reasonably in doubt here because he violated the clear bar on sitting judges making political contributions. He made donos. He donated literally to Joe Biden and to a group called Stop Republicans Political Action Committee. And then when he was called out on it, did not recuse himself and in turn gagged President Trump from talking. In addition, the Khan's daughter was the president and a part owner of an advertising company that Kamala Harris paid millions to, and other Democrats. They even ran advertisements specifically invoking the prosecution of Trump in her father's courtroom. She made a post about it. It was Adam Schiff who she was making these Facebook posts on, funneling money over to his campaign so you could donate to support another censured loser. In the face of all these undisputed and damaging facts, Juan the Con and his refusal to recuse at least created the appearance of bias, at the very least, and a noxious odor, just like Fanny. And it eroded the public trust, another clear ground for reversal. And so, nice intro there. We'll hit some of the highlights. We got a lot of the skeleton fleshed out. These are the questions that they're asking as it relates to each one of those. Did this judge screw up when he refused to recuse himself? They say, yeah, he did. So you got to reverse this. Did this judge screw this up by allowing insufficient evidence on the intent matter? Yeah, he did. And so the trial needs to be reversed, outcome, and the case dismissed. Did the trial court err by allowing the jurors to just pick a crime, any crime, whatever they want, it's good enough, and come up with unlawful means? Yeah, that was a problem. Also, is there immunity? Yeah, that's also barred. And you see how this works. Now, we get into it. More details on the background of this rigged case. Here we see that we get into the Clifford, this is the Stormy Daniels, non-disclosure agreement. Michael Cohen became the executive vice president of the Trump org, and he represented Trump on a number of things, especially things that were issues of concern. And in 2011, he persuaded a magazine, don't publish salacious and false claims by Stephanie Clifford, aka Stormy Daniels. The magazine paid her $15,000 for an alleged encounter between her and Trump. And that's in 2011. In 2016, the election is right around the corner. Stormy is now trying to regurgitate that claim. She is now seeking publicity for her false story. At the time, Cohen negotiated directly with Stormy's lawyer. They agreed that Stormy would be paid $130,000 as part of a non-disclosure agreement. She can't discuss it. Cohen set up an LLC, wired the funds from his own personal home equity line of credit. Trump's signature, not on any documents anywhere. Then in January 2017, Trump won. Just as President Trump was about to be inaugurated, Cohen approached Trump and Alan Weisselberg, and he says, hey guys, guess what? I handled this thing. It cost $130,000. The Trump organization had handled the president's personal finances for a decade. And so Cohen went over to Alan Weisselberg. He was the CFO at the time of the Trump org about the payment, and he didn't provide any specifics for its purpose at all. Now, Cohen also claimed that he was owed $50,000 for a different payment he also made on behalf of Trump for a company called Redfinch. Cohen later admitted he lied to Weisselberg. Cohen had paid Redfinch much less than that, but then he enriched himself unjustly by saying, oh, no, it was 50,000. It was like 10,000. He's like, oh, it's 50. Trump's like, okay, I mean, it is what it is. Weisselberg decided to pay back Cohen $180,000 in monthly installments throughout 2017, then doubled that amount to $360,000 to make sure that Cohen would be fully repaid even after paying a 50% tax rate. Weisselberg also added a $60,000 bonus after Cohen complained that his bonus from Trump was much lower. He's, what is this? I work hard for you. That brought the total payment to $420,000, $35,000 a month for 12 months. Then Weisselberg, the CFO, asked Cohen, says, send me invoices. Once the invoices come in, I'll pay you. I'll process the checks. February 17 comes around. Trump's in the White House, who Cohen had taken on a new role as personal attorney to the president. He emailed Weisselberg an invoice. Trump's the president for $35,000 for January and February pursuant to the retainer agreement. The message said personal attorney to President Trump. So then Weisselberg emailed another employee. He said, okay, yeah, this invoice is okay to pay per agreement with Don Jr. and Eric Trump. Everybody says, okay, pay it. Who had taken over running the Trump organization after Trump became the president. There's no mention of an agreement with President Trump in any document that he had any involvement with it at all. Maybe he didn't even know about it. Other employees of the Trump organization then processed the payment. They used Cohen's invoice. They created an entry in the ledger. So remember, invoice was a felony. Entry in the ledger was a felony, and the payment and the writing of the check was another felony. So every time Cohen sent an invoice and they entered it into the QuickBooks and then they issued a check, felony, 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 every month on repeat, like a Netflix subscription. Reflecting the language of the invoice and Cohen's role as the personal attorney, the payment was categorized as a legal expense under a retainer. The check generated by the computer system had retainer in the description line. So Cohen sent a bunch of invoices, basically identical from March all the way until December, 3 felonies a time. Each time the same process took place, there was a ledger entry, there was a check, and somebody signed it. It was either Eric Trump, Weisselberg, or President Trump himself did sign some checks to his lawyer. Now then we saw that Michael Cohen, only one person, Michael himself, has ever claimed that Trump knew at the time about Clifford's non-disclosure agreement or Cohen's reimbursement arrangement with Weisselberg. No one else knew about it. There's no evidence other than from Michael Cohen, who's a convicted perjurer. But even Cohen did not state that at the beginning. Up through the middle of 2018, in fact, Michael Cohen, he told anyone who asked that President Trump knew nothing about the reimbursement deal. No, he didn't know anything. Cohen even said that to his own attorneys in April 2018. Robert Costello confirmed it. He said, I have no reason to lie. He says, I swear to God, I don't have anything on Donald Trump. President Trump knew nothing about these payments. And his lawyers, many of his lawyers, would ask him that so that they could assist him in his own legal troubles. If you can give us something about Trump, then they'll let you go. But he didn't have anything. Indeed, from Trump's perspective, there would have been nothing noteworthy, let alone nefarious or criminal, about the payments to his personal lawyer. He's doing legal services, so he signs the check. Cohen had performed and was continuing to perform legal services for Trump and his family. He was making 35 G's a month, $420 a year, similar to the $525 per year that he was already making for Trump. Simply put, Trump had no reason to question these payments. He pays a lot of lawyers and no notice that there was anything even wrong about them. But by August 2018, Cohen's story had changed. As his own criminal conduct came under investigation, he freaked out. Remember, they set Trump up with my Russia collusion hoax. Then Robert Mueller came in. Then the Democrats are breathing down everybody's neck. Cohen starts to get nervous. Cohen began telling a diametrically opposed story, and Alvin took it and ran. According to this new version of events from the perjurer, Trump supposedly knew all along about the Clifford payment and the reimbursement scheme between Cohen and Weisselberg. Now, Cohen, he had clear motivation to fabricate that nonsense. He had been hiding millions in non-Trump organization income from the IRS. He had lied to his personal bank and loan applications. He had lied under oath to Congress in late 2017. The FBI investigated Cohen's crimes, and they raided his home and his office. 4 months later, Cohen pleaded guilty in a federal court and was sentenced to 36 months in prison and 36 months supervised release. Only then, notably, did Cohen make his about face and claim that Trump was behind all of this because the DOJ needed something. The Democrats who were leading the charge on this said, give us something and we'll let you go. Cohen later sought to parlay his cooperation with both federal prosecutors and Alvin Bragg to reduce his sentence. So he'll make up a story about the president in order to save his cowardly butt. Now, around when Cohen's legal troubles became public, Alvin formed a special task force to investigate the sitting president of the United States. And in fact, Alvin was not there yet. So this was the prior DANY. A great deal about that investigation is public because Mark Pomerantz, remember him? He wrote a whole book about it and threw a hissy fit, those guys. Mark Pomerantz, and I think Kerry Dunn was the other dude who resigned. Alvin came in. He's like, well, we can't prosecute Trump because your case is terrible. There is no case here. He didn't do anything wrong. And they just resigned and wrote this nasty letter. And then Mark Pomerantz wrote a whole book about it. And these guys were basically working for free just to go take out Trump because they're maniacs. And Pomerantz then blew the lid off the whole thing and revealed everything. Then Alvin Bragg had to turn around. Once Matthew Colangelo came down, Alvin Bragg gets elected. He comes in. Matthew Colangelo comes in. And They all start working with Tish and Alvey and all of them to take out Trump. This is the epicenter of their attack. Now, enthusiastic to join the task force and happy to work without pay, so glad they said that, Pomerantz joined the already 2-year investigation into Trump. In early 21, okay, so Bragg was there. Now, because I think Bragg got elected in 20. Now, Bragg's investigation at that point was unfocused and sprawling, so they did join after he was elected. Everybody seemed to be investigating everything. Now, although acknowledging prosecutors should target crimes and not criminals, Pomerantz believed that Alvin was warranted in throwing the book at Trump because Trump, although not a cold-blooded killer, he had a history of unlawful behavior. He's just like Al Capone and John Gotti. Now, to Pomerantz and the Democrat hack lawyers who became prosecutors to work for free, no amount of new tricks was off limits in their effort to try to charge him. He wrote a whole book about it, tried to sell it to his lefty lunatic friends. Now, critically, the charge had to be a felony. He admitted that Alvin had little interest in the Clifford payment if it resulted in only a misdemeanor. But Pomerantz thought that Bragg could argue that the hush money and the phony invoicing scheme were false business records, and the records were false, he thought, because they weren't for legal expenses. And, of course, we know Cohen was actually providing legal expenses, but even if the records could somehow be shown to be false, that's illegal. But again, Alvin was not interested in a misdemeanor. So instead, Alvin doggedly searched for some way to transform this into a felony. How can we do it? Because falsifying business records is a felony if it's done with the intention of committing another crime. You're falsifying the business records to commit a further fraud. He's thought, well, what if that crime was a federal election law violation? But as we already talked about, that's preempted by federal statute, so they can't really do that. This was on the theory that it was an illegal campaign contribution, even though the feds investigated that and did nothing with it. But recognizing that we have a preemption problem because the feds actually have the jurisdiction over that, Bragg had been concerned that the predicate other crime, it has to be a state crime. The other unlawful means, what is that? Not a federal campaign violation, because we'll get preempted on that and lose. But Bragg saw no comparable state crime. We don't have state laws for this because they're federal violations for federal office. No state crime that Cohen or Trump intended to conceal. And so he dropped the notion of prosecuting based on Stormy. Alvin said, I can't do it. We remember they flipped out. So then at Pomerantz's direction, this working for free prosecutor who says we have to take out Trump because he's like John Gotti, that decision 2 years later, this time Pomerantz urged internally that Trump was going to conceal the predicate crime of money laundering. He said, well, Clifford committed extortion and that Trump had purportedly laundered the proceeds of its own victimization somehow. Now, Pomerantz, so the timeline's a little bit, wonky here because Cyrus Vance was the first DA who was there first. Pomerantz was reporting to him, Cyrus Vance, and he raised his eyebrows at the notion. He's saying, wait, you think Trump was the victim of blackmail? And so you're going to charge him? Stormy's trying to extort him and blackmail him, and so Trump is laundering money to Stormy? Like, that's your theory? All right. So Cyrus didn't bring the charges. Alvin had to come in and take over. Now, by February 2022, unwilling to give up on the effort to charge Trump with a felony, Pomerantz conceived yet another theory. Said Trump had supposedly overstated the value of his assets, but prosecutors considered this one weak as well. And one key flaw here, it depended on Michael Cohen's word. And one supervisor in Alvin's office explained she did not trust anything he said at all because he's a liar. So then Pomerantz had to persuade the new DA, Alvin Bragg, to authorize the first ever prosecution of a former president. And Bragg, just like his big sister, Letitia, they both campaigned on investigating Trump. Even Alvin boasted. He said, I have investigated Trump and his children, and I've held them accountable before, and I'm going to hold them accountable again. But even Bragg apparently viewed Pomerantz's dreamed up felony theory as too tenuous to prosecute because it's not real. So in response, Pomerantz threw a fit. He resigned and wrote this nasty letter, like they do in their little blog posts. He probably felt really good about himself. He resigned and authored his tell-all account. He was publicly chastising Bragg for supposedly failing to hold Trump accountable for his crimes, which don't exist. Pomerantz's resignation and his media tour ignited a firearm of criticism and political pressure on Bragg, who's weak. Then only a few months into the job as DA, Bragg responded with a highly irregular public statement. And we remember covering this here. It was like back and forth. Alvin looked like, man, he's just like, just leave me alone, man. I just want to, eat my meal. Bragg responded with a highly irregular public statement, insisting that his investigation of Trump is not over and we could still move forward with an indictment. So don't get mad at me. But after 4 years of turning over every rock, Alvin still had no basis to file a felony. Bragg remained stuck with the Michael Cohen theory, and he called this the zombie case. It's been around forever. They kept trying to revive it. The prior prosecutor couldn't do it. Pomerantz is working on it for years. Alvin gets elected. He tells Pomerantz no. Pomerantz throws a fit, and then Alvin's like, okay. Plus, by now, the 2-year statute of limitations, even for a baseless misdemeanor charge, had already lapsed. It's over. The clock expired. Shot clock's out. You're out of time. Game's over. Now, they didn't care because they had an election to win, and Trump was going to obliterate their candidate. So in November 2022, Trump officially announced his candidacy. Less than 3 months later, Bragg impaneled the grand jury. Oh, dang, he's running. We got to indict him immediately. Jack Smith was playing the same game. Now, on March 30th, 2023, right in the middle of the Republican primary campaign, you remember this, we had a little Ron DeSantis action going on, and Trump was out there. Alvin came out with its long-sought indictment. Everybody went, what? 34 counts? Felony? Falsifying business records in violation of New York law. We all said, what? Each count was related to the $35,000 payments to Michael Cohen, the perjurer. 11 charges from invoices, 11 charges from checks, and 12 spreadsheet entries. 34 felonies. One set for each payment owed. Trump's personal account all came out from this. The checks were drawn. And in an accompanying statement of facts, it alleged that these records were supposedly false. Why? Because Michael Cohen was not being paid for legal services at all. And there was no retainer agreement. Now, notably, neither the indictment nor the statement of facts even ever specified what the other crime was. No one knew. They didn't tell us. And it should have been fatal at some point throughout this case, but the judge just kept, well, we'll figure that out later. We'll figure that out later. And then we got to the end of the trial, and then the judge told us, it is whatever you want it to be. It was thus unclear how they turned these misdemeanor charges into felonies under the statute. So then in April, Trump exercised his right. He said, I want to see the bill of particulars here to specify the exact predicate crime, April 2023. Alvin, though, wrongly refused that appropriate request. He says, I don't need to tell you about my theory. What is the underlying unlawful means that makes up your basis for the other crimes provision that allows you to extend this by calling it a felony and extend the statute of limitations to bring this case now? What is it? Alvin said, you don't get to know. You think this is America? You think you have due process and you get to know the nature of the charges against you and exercise the confrontation clause to confront those charges? No, this is New York City. It instead responded that without limiting the people's theory at trial, the other crime could be any one of these. Remember, they said, well, it could be New York election law, could be this one, or it could be New York tax law, that one, or it could be New York penal law, this one, or this section over here, or it could be Federal Election Campaign Act violations, 5 options, multiple choice test. If you guys can find a crime or you have an opinion on the crime, they're totally different. Just pick one. You don't need to be unanimous on it. The judge allowed it. Now, this law is particularly obscure, this one here that they're citing. It's never even been prosecuted in New York history. Never. And that makes it a misdemeanor to conspire to rig an election. But even Bragg even refused Trump's request that he be told what unlawful means. What does it mean? Doesn't want to answer that question. In May 23, Trump removed the prosecution to the federal district court. He says, I'd like the feds to handle this since it seems like you're alleging federal election violations. Let's go to federal court. He said removal's proper because this also relates to my official acts as president. We had testimony from his comms director and his personal assistant inside the White House and was based on alleged election law violations. Trump emphasized, he said this is a federal offense, apparently, according to them. Alvin Bragg said no, said there is no connection. The trial has nothing to do with Trump's official duties and responsibilities as president. He lied right at this stage. And then at trial, talked all about what was happening inside the White House. And said because it has no connection to his official responsibilities, it's not subject to federal jurisdiction. He said the charges are not limited to these two claims, and all of it was a lie. In July 23, relying on these assurances, which were fraudulent, to the federal court, the district court said, well, I mean, the prosecution is saying he's not relying on any federal laws or statutes or official acts at all. So if it has nothing to do with us, we'll defer to Bragg and send it back down. Vitally, however, the federal court agreed with the president that an FECA, a federal election campaign law, would in fact preempt New York law. But if Bragg's not using it, then we can't have the case. So we'll just send it back down to New York. February 24 comes around. Election coming up soon. The U.S. Supreme Court said, we're going to hear the Judge Chutkan January 6 case that was brought by Jack Smith. Trump says, I've got immunity. Trump promptly moved to adjourn his upcoming trial in Mercan's case because the Supreme Court was going to decide presidential immunity. Judge Chutkan had to stop her prosecution, much to her chagrin, very upset about doing that. And it was the right call, because the Supreme Court needed to decide. Now, Judge Juan the Khan Mercan, he could have also done that, but he didn't. He says, can you order Alvin Bragg to not introduce at trial any evidence of official acts? And he said, no, I'm going to deny that motion because the Supreme Court has not heard this yet. We're going to have a decision from them, but they haven't decided. And so I'm just going to let this move forward. And I may renew it at trial while we wait for the Supreme Court to see. Then on March 26, right before jury selection, the trial court, Judge Khan, he granted Alvin Bragg's request to gag the president in the middle of a presidential campaign, to gag him. He can't know the full nature of the charges, can't even talk about it. The judge refuses to recuse himself, and they were doing this because they thought, we're going to get away with it. We're going to steal the election, and there will be no consequences for this, so they can do whatever they want. The court barred President Trump in the middle of a campaign from even making any statements about Michael Cohen. Cohen was constantly out in the media every day, urging the public to say Trump is guilty, and to vote against him. The court also prohibited any public discussion about the judge's daughter and her paid political work. The judge said, don't talk about my daughter. So what if she's raising money for Democrats? The court later denied the petition seeking review, and case went forward. Trump also then in April said, can we move this court to another district that's not as rigged as this one? He made clear that the jury pool had already been exposed to such overwhelming negative media coverage about this prosecution. According to a survey, 61% of jurors had already said Trump is guilty, compared to 37% or lower in the surrounding counties, and denied Trump's request for a stay. And the full panel denied it. You have to sit here in this corrupt judge's courtroom and just eat it. And it's interesting, right? They didn't let him move the case. They didn't force this judge to recuse. And yesterday we talked about the Charlie Kirk prosecution against Tyler Robinson and how we still haven't seen him on camera the last two court proceedings for whatever reason. Don't even know if the judge has, but all right. But they are, in that case, ultra concerned about the prejudice that the jury might have if you see him in prison gear, prison garb. Well, it could, we want to protect against that. Look what happened here. They allowed Michael Cohen to run his mouth while gagging the defendant in the middle of a presidential campaign. Yeah, so it's like, why is an alleged assassin getting more protections from the courts in Utah than President Trump a former president got in New York? It's because this was a political attack. Now, what happened is the trial. Under a worldwide media spotlight that we covered at length, Trump's trial began with opening statements, April 22nd, 2024. 6 weeks went by, And they made Trump go there every day, remember? They sought to persuade a judge and a jury of two key points. They said Trump, quote, was involved, that he was actually connected to the Stormy Daniels NDA and the payments. And two, that Trump did have the intent to commit or conceal another crime. What was that? And that is what transformed this into a felony from a misdemeanor. A misdemeanor couldn't have prosecuted, so they had to shove it in this provision of another crime. What crime? Well, whatever. Don't you have to prove that other offense? Just like a regular offense? It's like beyond a reasonable doubt? The other crime, what is it? They didn't care. Now, for nearly all of the trial, okay, we were sitting here going, where are they even going with this? The defense had no idea. You remember when Edmond Dantes in the Count of Monte Cristo, I think that was his name, when he said, what are my crimes? What are my crimes? What are my crimes? As he's being hauled off to prison. Same thing happening here in a much sneakier way. Now, Bragg relied exclusively on Cohen's testimony in trying to prove that Trump knew all along that the payments were reimbursement, and Michael Cohen was the star witness, and he's a convicted perjurer. Now, Cohen claimed that he routinely updated Trump by phone. Now, trying to buttress this story, they introduced records of phone calls between Trump and Cohen of October 2016. But no evidence corroborated Cohen's account of what was said, and Cohen admitted that they discussed a bunch of other matters. So Cohen also said that Trump personally signed off on this plan. According to Cohen, immediately after he and Weisselberg discussed this mere days before the inauguration, the two men went to Mr. Trump's office where Weisselberg explained the arrangement. Again, no other evidence to corroborate that account. And if you recall, they also charged Alan Weisselberg so that they could sideline him as a witness and say, oh, we're going to get a conviction out of you. So if we have you come in and testify to go against the statements of Michael Cohen, we'll just impeach you saying, oh, you're a convicted felon. And you've got, or maybe as part of his plea deal, I think he had a plea deal. He was like in his 70s. They wanted him to go to jail and all this stuff. Just take him out of the equation. Bragg did not even call him to testify. Yeah. But Bragg did call Stormy Daniels, whom the trial court allowed to testify in lurid, gratuitous, and prejudicial detail about the alleged encounter with Trump. And the defense was objecting. She was talking about all sorts of disgusting stuff. And the judge is like, this is really exciting for me for some perverse reason. He's like, I'd like to hear more about Trump's genitals. Yeah, tell me more about, you're like, Judge, this is completely inappropriate. We know that you like this as a little romance novel or something. It's like helping you guys get off on your prosecution of Trump, which makes you very happy with yourselves. But it's inappropriate. This is a court of law. Now, seeking to conjure up a felony to make one out of thin air, Alvin tried to prove that the payments to Michael were going to conceal a conspiracy to influence the election. And there was a meeting at Trump Tower. And there was a plan by Trump, Cohen, and Pecker, the CEO of the National Enquirer, and that Pecker would act as eyes and ears for the campaign and bury these stories. But as trial testimony showed, we covered it here, there was nothing unusual or untoward about tabloid editors working with celebrities. They provide heads up and they squash stories. Pecker testified that these are standard. These are SOPs, standard operating procedures here. They're mutually beneficial, and we protect everybody. We did it with Arnold Schwarzenegger. We did it with Tiger Woods. We did it with Mark Wahlberg. We did it with Rahm Emanuel. And at any of these meetings, there was no conversation about a financial dimension at all. But nevertheless, Alvin Bragg came out, and he tried to paint a misleading picture, calling this whole thing a conspiracy. It was executed through 3 different transactions. He said the first was the Stormy Daniels NDA. Another one was a deal between AMI and a Trump doorman called Dino, and this other person called Sajudin. Someone claimed that Trump fathered a daughter with a maid. They said, get out of here. Here's $30,000. Get out of here. The third was a transaction between Karen McDougal. McDougal got paid $150,000 for her story, and AMI didn't publish it. He said, these are very common. This is what we do in the tabloid world. It's just standard. So these dealings had no legal relevance at all, Sajudin and McDougal, to any of the monthly payments that Michael Daniels was paid. AMI was not a party to this at all, to the Stormy Daniels stuff, period. Indeed, Pecker himself said, I don't consider Stormy Daniels to be a part of any agreement that we ever had. And Bragg never explained how any of this was applicable to Trump. But at the conclusion of Alvin Bragg's terrible case, Trump moved for a dismissal. He said, you have not produced legally sufficient evidence. You have to at least check the boxes. Like if it's DUI, you're driving a car, actual physical control with a blood alcohol limit over a certain thing. If you can't just even meet those baselines, you're not good. Was he not driving a car? Why is he charged with a DUI if he wasn't driving a car? Is he walking on the street? Then that's not sufficient. So it's obvious in a case like this, but the same thing happened here. What is the evidence of the other crime? I know it's very obtuse here by design, but the judge just said, well, we're going to reserve a decision on that. I think maybe I'll decide that later, of course. Not until we got to the end, until it proposed jury instructions, did Alvin finally reveal the alleged predicate crime. Despite Alvin Bragg's earlier representation to a federal judge, he said to the feds, no. We're not even going to have any election law in this at all. So federal court, don't take this case away from me because we're not going to be relying on federal election law. Oops. Then Bragg came into the state court and he instructed the jury that the other crime is a violation of New York election law and no other crime. And again, what did the federal court say? It was preempted. So Alvin Bragg's theory was that Trump allegedly falsified internal payments to cover up a conspiracy to promote or prevent the election of a candidate by unlawful means under New York law. The instructions then identified 3 kinds of unlawful means that they could pick from. All of this in furtherance of a conspiracy. And any one of these actions is sufficient to meet that standard. Violations, look again, right there, Federal Election Campaign Act. Oh, yeah. So he put that back in. He just told the federal court that they would not rely on that at all. Otherwise, they would be preempted. Then he shoves it in there. They're quoting it. Puts that into the jury instructions. Alvin's a liar. The falsification of other business records or a violation of tax laws. Pick a crime, any crime. You have no notice. Doesn't even matter. Can't defend against any of those because it could be one of 3. And they could just pick. I mean, how do you not get a conviction? Well, I don't think it's these 2, but maybe this one. I don't know. Alvin spent virtually all of its summation in their closing arguments talking about federal law. He said these are federal violations. These are campaign contributions when he was paying these people off. And the payment to Stormy was a campaign contribution. Now, as an alternate unlawful means, he then said, well, it could also be falsification of business records and the bank records also associated with the wires. Those could be fraud. And another thing is reimbursements. And so he concocted a felony. He combined 2 separate layers of misdemeanor predicates. This is a misdemeanor and this is a misdemeanor. But if you are doing one misdemeanor for the purpose of committing another misdemeanor, like the other predicate is also a misdemeanor, then one misdemeanor plus one misdemeanor equals a felony. Saying that, in other words, he couldn't prosecute Trump on the predicate by itself because it was a misdemeanor and it had already expired. So he just bundled that in to another misdemeanor and said, well, this is the crime that was the other crime. So it's 2 misdemeanors with no basis for a felony, but since it's another crime, it's now a felony. According to Bragg, Trump committed a felony because he committed a misdemeanor. See that? With the intent to commit or conceal another crime. The other crime, what was it? It was another misdemeanor. And that unlawful means was a violation of any other 3 laws. It's like inception of criminal charges. Like, where are we? What layer are we at? As a bipartisan group of commentators explained, this was a house of cards. They just stacked on top of one another, all to rig it. Compounding its error, at Alvin Bragg's urging, he says, Judge, please help me. The trial court wrongly instructed the jury, told the jurors, you don't even need to be unanimous, quote, as to what the unlawful means were. Just pick one. We don't care. And if you do, we can conclude that Trump conspired to act with unlawful means. Well, what were the unlawful means? Anything, whatever you want. Bragg twice emphasized this in summation. He said, You don't even have to agree what those unlawful means are. Just completely scummy. And thus the jury convicted, so long as each juror individually concluded that Trump had entered into and intended to conceal one of three different purported conspiracies to influence the election, even if each juror concluded that he did not enter into any of the other proposed conspiracies. So there's disagreement between the jurors. I think he was over here. Well, I think he was over here. Isn't that reasonable doubt? No, I'm very sure he's over here. No, I'm pretty sure he committed this crime. Okay, so there's complete disagreement here. And they could do that. The trial court also rejected Trump's request for a special verdict form where they would also define, right, check the box. What was the unlawful means? Do you think it was this? Do you think it was this? So that we could see. Judge said no, because if we could see, then it would show that there is reasonable doubt and this whole thing is rigged. So then they came back with a guilty verdict on 34 counts. How can you not? The trial court denied without any explanation a judgment of acquittal motion. No, denied. We're not going to give that. So then on July 1st, 2024, election is coming up. Supreme Court came back down in the Judge Chutkan case, and they said, oh, yeah, the president does have presumptive immunity for all official acts. Yep. And the left and this judge couldn't understand that concept, or they could, they just didn't care. They wanted the conviction. So the Supreme Court said that this immunity not only protects the indictment, but it also bars unequivocally the use of any evidence about this conduct. You can't use protected conduct against the president, even in a state court trial. The trial court, though, denied the motion, and several weeks later denied another motion to dismiss the indictment, all relating to his status as the president-elect. How delicious was that? December 24, Kamala Harris, who's installed by the Democrats, loses, gets obliterated. And they said, well, we won now. Now, prior to sentencing, Trump went to the Supreme Court for a stay. They said, we've got immunity on this. Supreme Court denied the stay. They said, well, we'll just deal with this later. So if you want to convict him now, that's fine. Then he can appeal it after the conviction, and the Supreme Court will deal with it later. Notably, 4 justices dissented. They said, well, we would have heard this case right now. But then on January 10th, just days before Trump's second inauguration, the trial court sentenced Trump to a term of unconditional discharge. That was the penalty, which means no penalty at all. Judge couldn't put him on probation, couldn't charge him with a fine, couldn't imprison him because he was the president-elect. He's done. So the judge just said, unconditional discharge, no penalties at all, and he walked into the White House. So now, obviously, we're appealing this, and here's why. This case is a case of many damaging firsts. It's the first time that a New York state statute has ever been held to regulate a candidate for federal office. Also, the first time a jury has convicted a former president of a crime based on testimony about his official acts in office. Also, the first time that a jury has been excused from unanimity. Also, the first time that the phrase intent to defraud has been construed to encompass a vague intent to deceive the voting public, whatever that means. And the first time that a judge presided over the mid-campaign prosecution of a presidential candidate, even though the judge himself recently donated to his opponent and his daughter sold partisan political ads that supported that prosecution. We lived through that, man. In permitting this unprecedented prosecution to proceed, the trial court committed at least 5 independent legal errors, idiot Judge Merchan. Each independently requires that Trump's conviction be set aside. Here's how bad this judge is. Trump's wrongful conviction was preempted. They morphed it into a state crime, even though the federal rules supersede it. And the judge gave the jurors 3 options. Just pick a crime, any crime. We understand that it is all preempted and they shouldn't have even heard it. Under the Supreme Court law and the Supremacy Clause, you can't charge state crimes for federal campaign finance violations. Here, Alvin Bragg did exactly that. The plain language of the statute is dispositive. It says, Congress, it chose expansive language. They said any provision of state law as it relates to federal office is ours. And Alvin can't take those. And everybody knows this. Both federal and New York courts have unanimously recognized that the federal law squarely preempts state law. But they didn't care because they needed to take Trump out. We understand the preemption argument. Let's see what else is there. And it's invalid. It's preempted. You cannot charge under state law for this type of an offense. The conduct that you're alleging falls within the purview of the federal government. And so on this basis alone, the conviction must be reversed and the charges dismissed. Trump repeatedly brought this up, but the trial court didn't care. In fact, Alvin Bragg opposed the removal to federal court and then brought the same evidence back into the trial level, basically lying to the feds. So that is pretty obvious. Lots of federal election law being preempted. Moving on to presidential immunity. They introduced a bunch of evidence that should not have been introduced. The Supreme Court already said the president enjoys presidential immunity, and it bars the use of that evidence at a trial. Judge Chutkan blown out on that one too. In violation of those mandates, though, Judge the Khan Merkhan repeatedly admitted testimony and private records of the president, his advisors, all of it probing official conduct, and then invited the jury to read into the president's motivations for his official actions and second-guess their propriety. Here are 4 different categories of official acts of evidence that was introduced. We talked about many of it. Alvin Bragg subpoenaed Hope Hicks, the White House comms director. She said and discussed a bunch of things about how he would like the team to respond. She testified that she was talking to White House officials and detailed all of the coverage that was happening from inside the White House. Now, all of that testimony is prohibited. Supreme Court said, can't do it. All of this stuff is official conduct. The president is allowed to talk to his comms director. You can't bring that in at trial against him. And now, if there was any doubt, Ms. Hicks also testified without contradiction that her official responsibilities, that her job was to coordinate communication from the White House. And they brought that in as trial, as evidence against him, that he's constitutionally allowed to do that. You can't criminalize the president for that. They also said, well, this isn't an official conversation. The judge said, this is about an affair and it's not about public concern. And so that is not going to be immune. And so the judge wrote that out. But the Supreme Court has already said people can speak for the president publicly. All of that is conduct within at least the outer perimeter of the presidential duties. All sorts of things. George Bush's college grades, Obama's relationship with their former pastor, and more. And this was also official. Trump also made statements on Twitter. They may not have liked the statements, but those were from the president. These are posts, May 2018. Other posts also criticized Cohen. Now, these were official acts. Most of Trump's communications were in the form of tweets. Those are clearly communications from the president. He used an official communications channel, and the court was wrong on this. They said, well, Trump talking about Michael Cohen doesn't advance a policy concern or other public interest. Yes, it does. It's defending the president against smears from partisan hacks who are trying to wreck his administration with salacious scandals. But the Supreme Court also made clear that presidential speech is official when the president believes that he's persuading Americans on a matter of public concern. And it's up to the president to decide when and how to speak to his fellow citizens. It's not up to the trial court to second guess the officialness of the statement. The judge doesn't get to decide, actually, that's presidential, because he thinks it is. To be sure, the Supreme Court case also recognized that the president may also speak in an unofficial capacity. And the testimony here literally came from Madeleine Westerhout, Oval Office operations, and others, all in official business. Similarly, Alvin Bragg said that Trump was talking to people in his administrations, in particular, Jeff Sessions. And they wanted to introduce other evidence, but he's allowed to talk to his attorney. They reasoned that this was all outside the scope of their powers and that the AG doesn't know anything about the FEC stuff. But they say that the FEC is a fourth branch of government. In other words, that Trump doesn't have supervision over that, which clearly he does as the executive. And finally, they also subpoenaed Madeleine Westerhout. She came in, remember the testimony? She talked about work habits, preferences, practices, contacts, asked about a phone call to Melania. Based on her former position, she literally testified about calls made in the Situation Room, testified about how Trump would come up with his official statements. And the judge invited the jurors to sit in judgment of all of those things. And so all of this is reversible error. Trump's evidentiary immunity arguments are not waivable. They're fully preserved and they're supported by the Supreme Court. Second, violations of that immunity are structural errors. It's not harmless error. The case requires an automatic reversal. And third, even if there is harmless error, the trial court's admission of official acts is not harmless beyond a reasonable doubt. And so they screwed up. Trump's arguments have been fully preserved in the trial testimony. Immunity cannot be waived. We made multiple objections. And long before they ever took the stand, Trump filed pretrial motions. We already sought to preclude official acts evidence. We wanted to preclude Cohen's testimony, but the judge didn't care. He said, I'll renew these motions after the jury's picked. All three motions were denied. Trump again, before Hope Hicks took the stand, renewed his objections again. Trial court overruled the objection. And they even told the court that you don't need to object as to each question. Okay, I've already ruled on this. And so shut up with your objections. Then the court came back down and said, well, you didn't object enough. Let's see if they go there. This court should resolve these serious problems. And these are per se reversible errors. They violated presidential immunity. These are structural errors that are critical. There's other case law, other rationales that support this, and lots of case law that we're fast forwarding through right here, as you can see. None of this was harmless. It was critical and part of the case. And Michael Cohen, who testified, is a serial perjurer. He's a convicted fraudster. He had previously told even his own attorneys that Trump had no contemporaneous knowledge of any of this. And Cohen changed his story in late 2018 to try to garner leniency because he was going to prison. In concluding otherwise, saying that Michael Cohen was very credible, a reasonable jury could have distrusted Cohen if we could have talked about some other elements of this person. His credibility was so impeachable that Alvin Bragg apparently told Pomerantz that he could not see a world where Alvin would indict Trump and call Michael Cohen as a witness. Now, in spite of his unreliability, they repeatedly invoked evidence to bolster their allegation that Trump knew all along, and Alvin repeatedly brought it up in his closing arguments. He also brought up his statements on Twitter, which were all protected, and emphasized more conversations about the attorney general, which Trump is allowed to talk to. So all of that means reversal. It was impermissibly introduced at trial, and the case needs to be reversed. Now, as we continue through this burner of an appeal, they also say the judge totally botched the case by saying the jurors could not be required to be unanimous. And the trial court told the jurors that to convict, they had to be unanimous on unlawful means, but after Bragg made the request, not unanimous as to what those unlawful means were. Pick a crime, any crime. This was reversible error. First, New York law requires unanimity. Even unlawful means has to be defined. And second, convicting Trump without this violates his due process rights. You're like Edmond Dantes. Have no notice of the charges, no capability to confront your accusers because you don't even know what they're accusing you of. You must prove independently every element of the crime. But Judge LeCon didn't require that. They go through all the details of the statutes. We'll fast forward through a lot of that. Here's what the statute says. You got to go into it. All this is case law. For example, a defendant cannot be convicted of conspiracy if 6 jurors agree that he agreed to sell drugs and 6 others agree that he conspired to commit securities fraud. What is the conspiracy? Is it securities fraud or is it drugs? In that case, the defendant would have been convicted of 2 crimes on a non-unanimous jury verdict, and the convictions would have to be thrown out. This is the same. If half the jurors there thought it was a conspiracy to influence the election based on federal law, and the other half believed it was unlawful means, which was conspiracy to influence the election in another way, they don't agree on the elements. And the Supreme Court has said, you got to agree. Same reasoning applies here. And if there is any ambiguity in this, then you got to flesh that out to flesh out the disagreement. You have to encompass all possible elements so that we can be clear on what the crime actually was. Other examples, larceny, burglary. As for burglary, how that works and more. But if you have a jury say that we can just agree on whatever we want, it violates the Constitution and the concepts of due process. More Supreme Court case law here on how important this is. And in addition, that was also reversible error. So as we come to the conclusion of this appeal, they say there's also no intent. Trump moved for a dismissal because they did not prove any intent to defraud anybody. The court relied on its earlier ruling, and this was an error. We need to show under New York law an intent to cheat or deprive another person out of something of pecuniary value, financial value. Here, no reasonable jury, based on the evidence presented, could reach that conclusion because he didn't intend to defraud anything. You have to look at the formal definition of what defrauding is. And for many years, the intent to defraud in the jury instructions were pretty clear. And other appellate decisions have explained what it means. So does this treatise. But under the traditional meaning, this court must reverse and dismiss. No evidence supports any conclusion that Trump intended to cheat or deprive anyone out of property or anything of value in any way. And the judge allowed the language to be perverted. They changed it to take on a broader meaning. And Bragg did not establish any of this. Didn't establish there was intent to interfere with regulators or any of the other claims. Other cases, these other prior case law decisions explain what the standard actually is, and they drop below the standard. There was no evidence that Trump intended to mislead voters in 2020. And so he offhandedly brought that up in summation. Said Trump's going to run for president again. So the jurors on there go, oh, we're just going to vote him out right now. And so they erred also. Another good final section. The New York rules of judicial conduct say this judge should have recused himself from this case, and he didn't. Failure to recuse in these circumstances means he gets a new trial. In this case, Judge Juan the Khan Mercan repeatedly refused to recuse, even as Trump presented more evidence corroborating his apparent bias. To begin, he made contributions to Trump's political opponents. In July 2020, while as a sitting judge, he donated $15 over to Joe Biden for president, then donated $20 more to 2 PACs, one of those called the Stop Republicans PAC, a group that is explicitly created to stop President Trump. Each of these contributions was a violation of judicial conduct, not allowed to do it, and that alone, these political contributions alone, required recusal. New York has a bright line rule. You got to go if there's even an appearance. Now, the judge didn't care. He prosecuted a Republican candidate for president in the middle of a presidential campaign, even after making donations to literally stop Republicans from winning. This case could not be more politically sensitive, but in the prior election, the Khan judge had publicly donated to a candidate and was again his opponent in 2024. It's the same opponent. He also donated literally to stop Republicans. And so you should reject his reasons for declining. He said, well, they were just small donations. Doesn't matter. Because contributions are legal, they generally don't create an appearance of impropriety, said the judge. But judges are different. Political contributions by judges are different. Contributions to judges follow one set of rules. It could be de minimis, but not contributions by judges. So the judge was citing basically the rules for him getting paid, not him making the payments. Now, at minimum, the cumulative effect of all of those donos leads some to question his impartiality. And his daughter was also a lib hack too. Specifically, she was the president and part owner, the daughter, of Authentic Campaigns, a digital marketing agency that created content for Democrats because they're terrible at it, like Kamala Harris. And the campaign, Kamala, paid the judge's daughter's company, Authentic, nearly $5 million. Isn't that fun? And the dad, of course, wants his daughter to do well. In 23 and 24, Authentic again created digital content for Democrats. They produced digital advertisements and fundraising pitches for pencil neck Adam Schiff, the censured loser senator, who paid Authentic. He paid them $10 million. And the advertisements literally mentioned Trump's prosecution. They said the Manhattan DA's office has indicted Trump for criminal offenses. Give Adam Pencilneck $10 to his campaign right now. But both Authentic and the judge's daughter stood to benefit from daddy's decisions in the courtroom. If the judge dismissed the indictment or issued rulings that cut short the trial, Authentic wouldn't be able to run those advertisements, and Pencilneck wouldn't get your $10. So under these extraordinary circumstances, this judge was required to recuse or provide sufficient information to show that he is not biased, and he didn't. In another case, he also was biased. In fact, when they prosecuted Weisselberg, the CFO of the Trump org, he was forcing them, he induced Weisselberg to cooperate by saying that, you're going to get a good deal if you cooperate. And he assumed an advocacy role. You really should take this deal here, Mr. Weisselberg. And he said that he referenced some 3-page opinion letter from the Judicial Ethics Committee. But they said the logic is hard to understand here. If contributions to President Trump's campaign would have been disqualifying, as they implied, then surely a contribution against him would have also been problematic, right? And he did. What would happen? Do you think Alvin Bragg would be mad if Mercon donated to Trump? What if they donated $35 to Trump? Wouldn't you say probably should get a different judge there? And they also said, well, the donations were old. So he's cheap and they're old. So we have a lot of elections. And they said he's fine. He doesn't need to recuse himself. So in conclusion, 111 pages of a beautiful appeal. They write, as Justice Holmes wrote nearly a century ago, criminal laws must be applied in a manner that the common world will understand. Bragg, though, made a mockery of this. Despite years of rifling through Trump's business, Alvin could not even find a felony charge. So it concocted an elaborate theory, never before pursued in New York, plainly preempted by federal law. Like every criminal defendant in the New York courtroom, Trump was entitled to a fair trial before a properly instructed jury and a neutral judge. Instead, he was convicted after a trial that featured clear and repeated constitutional rights violations by a judge who was required to recuse and didn't. And for this reason, you, the Court of Appeals in New York, should reverse the judgment of conviction and dismiss this corrupt indictment. Sincerely, Robert Gouveia Jr., Matthew Schwartz, James McDonald, Maxwell Gottschall, over from Sullivan and Cromwell in New York, attorneys for President Trump. So very nice decision here. We covered this trial at length, as we know, and now it's off on appeal to the New York Court of Appeals, which is called the Supreme Court over there. And we're excited to see what comes back down. We'll should see a reply from Alvin Bragg, who says, no, the judge was great. I was great. We did everything by the book. But we know what they were trying to do. And Trump simultaneously is also, once again, trying to take this up to the Court of Appeals. To the federal courts, because now we know on the record that they did bring in the Federal Election Campaign Act as a criminal predicate in this trial. So it should have already been removed. We've got two tactics happening now, one in New York, one back in federal court. Either way, a bunch of immune evidence was presented at trial. They relied on Michael Cohen, and they rigged the statutes in order to create a set of convictions. And now we're hopeful that we see a reversal of those in one final beautiful victory against these rigged prosecutors. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right, my friends. Now, we're not done yet. We have another 100 pages to go through. And this one is about the Biden pardons. And this is some good stuff right here. Biden's pardons, null and void. Big news for Liz Cheney and the J6 committee and Anthony Fauci and the rest of them. Oversight committee dropping a massive report that we're going to take a look at. You can see 100 pages here. The Biden auto pen presidency, decline, delusion, and deception in the White House. And if those executive actions are in fact null and void, maybe we'll see some prosecutions here. They posted this from Oversight today. Says Joe Biden was not running the show at all. Our new report exposes how Biden's decline was real and his aides covered it up. Aides didn't even know who was operating the auto pen to sign official documents and pardons, which is insane. Watch what they tried to bury, and we'll get into that video and the full report. But Pam Bondi also came out and says, woo, today, my team has already initiated a review of the Biden administration's reported use of auto pens for pardons. Says Comer and Oversight committees, this new information, this new report that we're going to read is extremely helpful, and his leadership on this issue is invaluable. We'll continue working with GOP Oversight to deliver accountability for the American people. And what's interesting about this is if they don't even know who is behind the auto pen, think about this in a criminal case context where you have, let's say, for example, a DUI case. You have a lot of evidence that needs to be assembled. In this case, generally blood or breath or something. And you have to create a proper chain of custody of the evidence. And if it goes missing, for example, if you have an officer transport a bodily sample from A to B, B to C, C to D, it goes into impound, evidence comes out, some forensic person takes it out, E to F to G. All of this, you got to follow the bouncing ball and connect the dots. And if you lose that, one of those components, letter C, is missing, that cop gets fired or killed or resigns or he's charged with another crime or perverting it, whatever, then everything that came after that, as it relates to that sample of evidence, is now questionable. And your case might be dismissed literally because the chain of custody has been broken. That's for a criminal case. Shouldn't we expect at least the same standard of excellence of following the custody of the permission from the president to a presidential pardon? You would expect to see that, but that's not what we're seeing. Here's a short snippet. We're going to come back to this, but just to give us a little bit of a preview on what this report is going to detail, here is a montage released by the Oversight Committee.
Was the number one issue
Ron
in the
Klain,
campaign
Chief of Staff.
the president's fitness or his age?
Did you ever see President Biden in a wheelchair?
I do not recall ever seeing President Biden in a wheelchair.
And new information now on the people in his inner circle and how the cover-up actually operated.
Senior aides that worked here until just a couple months ago, the beginning of this year, manipulating an ailing president for their own gain.
How much were you paid for your role in the campaign in 2024?
Just a little bit short of $4 million.
I'm sorry, how much?
$4 million.
You believe that the president should stay in the race. Your own financial stake in the matter was a factor in any way in your advice to the president?
I don't believe that.
And when it comes to President Biden's decline, the official word from Biden World about all these news stories is that nothing has been revealed this week that shows that President Biden was anything but an effective president.
Yes, I noticed that he was aging in terms of his physical condition. I noticed that, he shuffled more.
That he has more stumbling over words and gaffes that he did, at the beginning of the term.
His rhetorical skills were not as strong as they had been, and his speeches were less effective, I thought.
We talked about age. We knew it was an issue, and we tried to design a strategy.
We had a discussion at the senior advisor level about whether the president should have a cognitive exam.
Flashback now to the legacy media's complete denial of the president's cognitive decline.
Start your tape right now, because I'm about to tell you the truth.
Tell us,
and F
Joe.
you if you can't handle
No,
the truth.
F you!
This version of Biden is the best Biden ever.
His mental acuity is great. It's fine. It's as good as it's been over the years.
He is sharp. He is on top of things.
Do you regret saying that President Biden had a mental acuity? He had a sharpness to him.
I said what I believe to be true.
And you think he was as sharp as you?
I said I had not seen decline.
Come on. Oh, that guy's great. Come on. He looks at her. Come on. Are you kidding me? Right there. Are you kidding me? Elizabeth Warren. All right. So we're going to come back to this. Just a little bit of a preview there. But here is the final release from Oversight. October 28, 2025. They say this report is now out, explaining that the report exposes how Joe Biden's top advisors and his personal physician concealed his mental and physical decline from America. And let's get right to the report, because there's some good juicy stuff right in here. And here's what it says. The Biden auto pen presidency: decline, delusion, and deception in the White House. Writing the following. All right. James Comer and the Committee on Oversight has investigated the circumstances around Joe Biden's diminishing mental and physical capabilities. But even more troubling than a president experiencing a decline in mental acuity was the Biden inner circle, loyalists attempting to mislead the nation to ignore what we could all see with our very own eyes. Throughout Biden's term, people increasingly question the slurring of words, the mistaking of names, visible disorientation, confusion, dependence on his aides. Remember the Easter Bunny? No, Joe, get out of here. He almost had a heart attack. All of which we saw live. Serious cognitive decline, and it was a disaster. Now, the committee has investigated whether senior Biden White House officials possibly exercised authority of the former president or intentionally concealed his rapidly worsening state. And we found evidence to indicate they did both. One, exercised authority of Joe, and two, concealed the state of the president. The Biden auto pen presidency, perfect name for this, the BAP presidency, ranks among the greatest scandals in U.S. history. As Biden declined, his staff abused the auto pen and a lax chain of command policy to actually affect executive actions that lack any documentation, no chain of custody of whether they were in fact authorized. No records. While Biden became progressively less able to do the job, when every measure should have been taken to document this, to prove that Biden actually made the decisions, White House staff took shortcuts and ad hoc actions to keep the presidency floating. What the committee found is that there was, in fact, a cover-up of Biden's decline, and there is no record demonstrating that Biden himself made all of these executive actions that were attributed to him. Probably wasn't even doing any of it. A June 24 CBS poll found that 72% of the voters said Joe was gone, but his inner circle didn't care. Even his own physician, they testified in a way that drew very different conclusions than everybody else who could just open their eyes and watch. Those same advisors continue to hold those beliefs today. They don't even say it was a concern at all. After the launch of Joe's 2020 campaign, Biden's future comms director, Kate Bedingfield, described questions about his mental acuity as a disgusting smear tactic. And this is a false, misleading conspiracy theory. When asked directly on a podcast if Joe had dementia, Karine said, "I can't even believe you're asking me that question. Don't you know who I am? I'm a historic lesbian black woman who's a press secretary. Don't ask me that. That is incredibly offensive. Ron Klain said the same thing. Robert Hur, though, then came out and said, actually, Joel's brain is gone. They said this is gratuitous. And Karine and Ian Sams lied to all of us repeatedly because they're liars. The White House comm strategy was literally to obfuscate the truth. There were concerted steps to shield the public from simply observing reality. We had longtime physicians, Kevin O'Connor. He recklessly never conducted a cognitive exam of the president. Never. He invoked his Fifth Amendment right against self-incrimination and said specifically that he confirmed Joe was fit to be the president, a key figure in the cover-up, refused to answer questions about his duties, didn't want to talk about succumbing to political pressure, and closed up. Now, Dr. O'Connor, who had business dealings and also financial connections, is not the only participant in this scheme. Mike Donnellan, senior advisor to Biden, was responsible for getting accurate polling data back over to Joe. And he told the committee, I have this clip, that he was going to make $8 million by keeping Joe in the race and getting him reelected. These incentives, among others, motivated the inner circle to conceal the decline. Anita Dunn, another longtime operative who served as senior advisor, also told the committee that the former president's senior advisor reached a consensus to not give him a cognitive exam. No kidding. Despite persistent calls to do so, this revelation that the political advisors interfered with his health care is a cover-up, and it was corroborated by his second chief of staff called Jeff Zients. And here is just one clip of Mike Donnellan, and watch how this dude just struggles to even answer this very simple question. How much money were you paid? And how much money did you stand to be paid if Joe Biden won again?
That's my view.
Just to be clear, would the amount of pay you received for your role in the campaign, would that have changed depending on how far into the race President Biden made it?
My sense is that
spit it out. Come on.
In my view, the money was
go ahead.
That it was a guarantee for the campaign that we had a negotiation, and that's my memory of the agreement.
Would you have received a bonus depending on the way the campaign went? Was that a possibility?
How the campaign went.
Yeah.
Were there any circumstances in which you would have received a bonus?
Great follow-up.
Yes, it was.
What were those circumstances?
That Joe Biden would have been reelected president of the United States.
Oh.
What was the bonus of Ben?
I believe it would have been $4 million.
In addition to the $4 million that you were already
double.
Yes.
$4 million to work on the case, another $4 million if you win. How about that? So does he have an incentive to make Joe win regardless of his actual capability of doing the job? Of course he does. He's got 4 million of them. So that is the one guy who they reference. The inner circle and their resistance to any medical exams may have hurt Joe Biden's chances. And it was successful. It was not until the disastrous debate performance that anyone in Biden's orbit said, we might want to check this dude's brain. Zients specifically at the time called for a full workup. He says, what happened to his brain following the debate? Now, the cover-up up until the point was facilitated by extremely loyal senior staff. Annie Tomasini, Anthony Bernal, the work husband of Jill, both of whom pleaded the fifth. They don't want to talk. Bernal pleaded the fifth when asked if any unelected official or family members executed duties of the president. How come he can't just say no? Tomasini invoked the fifth when asked if anyone in the Biden family was ever asked to lie about Biden's health. Why can't she just say no? Dr. O'Connor, Tomasini, and Bernal, they all invoked the fifth. They all refused to be transparent because this is a cover-up. Even after Biden left, the committee was unable to determine the totality of actions taken by Bernal and Tomasini to conceal Biden's decline. And the committee is now urging the DOJ to investigate Bernal and Tomasini to get the truth for the American people. Now, our investigation revealed, says Congress, that Biden officials, at the behest of inner circles people, went to great lengths to prop up the former president after he began to lose his ability to function. These steps ranged from addressing Biden's makeup, his clothing, his schedule, the number of steps that he could walk or climb, the amount of time that Biden needed to read and spend with family. They worked on meticulously stage managing him, limiting the number of events he participated in, lightening his workload, making it difficult for even senior Democrats to talk to him, keeping cabinet meetings to a minimum, eliciting direction from Hollywood on State of the Union and other events. They used teleprompters even at small, intimate events to try to fake everybody. And COVID was very useful. Joe was like in a bunker the whole election, and they stole it. The investigation revealed holes in the chain of custody of the president's decision binder, which contained decision memos to be signed or initialed by Joe when approving or disapproving executive actions, as well as numerous instances in which the president's approval for an executive action was not memorialized. Among the most flagrant of these instances are the clemency actions taken in Biden's final days, which not only lacked a decision memo, but also raised serious concerns from Biden's own DOJ and their ethics lawyers about whether the president was aware of the criminal backgrounds when making these decisions to grant clemency to violent criminals. Testimony before Congress confirmed that the pardons signed on January 19th, 2025, which included pardons for members of Biden's family, were apparently the result of an in-person meeting in the final hours of the presidency, for which there is no, see that underline, there is no contemporaneous documentation. Nothing is in writing to verify that it came from Biden. Instead of actual documentation, the decision to grant these pardons was allegedly communicated secondhand to a Zients aide, a chief of staff person, called Rosa Poe, who then called Zients, who verbally authorized the use of the auto pen from home. Now, Zients did not even know who actually had used the auto pen to apply the signature after his aide, using an email account with his permission, communicated the auto pen was authorized for clemency actions. Zients did so without confirming that Biden did in fact grant these pardons after repeatedly telling people that he would not pardon his son, Hunter, let alone 5 other family members in the waning hours of his presidency. Poe subsequently sent an email on the chief of staff's behalf stating, "I approve the use of the auto pen for the execution of all the following pardons. Thanks, Jay-Z, Jeff Zients," hiding it in his assistant's email, just like James Clapper did, that corrupt DNI, who used his assistant's email to open up an investigation into the Russians because Obama ordered it to be done so. In light of Biden's cognitive deterioration and the cover-up, this approval process, writes Congress, calls into question the validity of all pardons granted by Biden throughout his tenure. Invalid. The committee deems void all executive actions signed by the auto pen without proper corresponding written approval traceable to the president's own consent. Null and void all executive actions from Congress, because there's no record. You can't prove that Joe approved anything. There's no documentation. Our findings detailed herein make clear that as Biden was losing command of himself throughout his time, his executive actions, especially his pardons, of which there are many, cannot all be deemed to be his own. And other people don't have the pardon power. Sorry. The authority to grant pardons is not given to his inner circle. It cannot be delegated to particular staff when his competency is in question. And even if his authority could be delegated, which it can't, it would have to be expressly delegated by him. The Constitution is clear. It says, the president, you have the power. That's it. He must make the decisions. And the courts can say if the president did not make that decision, then it's void. As we've said, charge them and then let them defend their pardons. The committee recommends the DOJ investigate all of the former executive actions, particularly pardons and clemency, to assess whether any legal action must be taken to void any action that he did not himself take. Can the DOJ actively do something to void them out, or maybe just charge them and then argue they're voided in court? Bunch of details in here. These are the key people all involved in the investigation, and many depositions also happened. Here you go. White House Staff Secretary Neera, Kevin O'Connor, the doctor, Ashley Williams, Bernal, Ron Klain, Mike Donnelly, we just heard from, Ian Sams, who said he met with Joe twice, special assistant to the president, met with him basically twice. And so let's hit some of the highlights in here and see what we've got inside. Now, Dr. O'Connor was complicit. He was Biden's physician and ran interference. He found in February 24, he said, Joe Biden's a healthy, active, robust 81-year-old male who remains fit to successfully execute the duties of the president. That conclusion, obviously inexplicable, but it makes sense when you realize that Dr. O'Connor had great incentives, including financial incentives, to participate in this grand scheme. And he refused to voluntarily speak with Congress. He got a subpoena to testify, but didn't want to talk. He said, I'm going to invoke my Fifth Amendment right and the physician-patient privilege. But he says that's inapplicable. You can't use that here. This is Congress. Now, as the official physician to the president and the personal physician to Joe for 15 years, he provided a lot of updates. And he is the only known person who can speak about Joe Biden's physical capabilities. Here are some questions that he refused to answer. Dr. O'Connor, who handled Joe, were you ever told to lie about the president's health, doctor? On advice of counsel, I invoke the Fifth. Hey, question for you. Did you ever believe that Biden was unfit to execute the duties of the president? How about no? Just say no. He doesn't want to answer the question because he knows the answer is yes. Now, we had more of his deposition, and I do believe I've got that queued up as well. Here's a little bit of it. Did Dr. O'Connor mislead the American people? He pleaded the Fifth many times over, and here is what that sounded like, courtesy of Joe Biden's doctor.
Dr. O'Connor, were you ever told to lie about the president's health?
On the advice of counsel, I must respectfully decline to answer based upon the physician-patient privilege and in reliance on my right under the Fifth Amendment of the Constitution. I am not a lawyer. I must follow my lawyer's advice in this matter.
Just say no.
Let the record reflect that Dr. O'Connor has invoked the Fifth Amendment right against self-incrimination. Dr. O'Connor, please be very clear. Are you declining to answer the question put to you solely on the ground that you believe the answer will incriminate you?
On the advice of counsel, I must respectfully decline to answer based upon the physician-patient privilege and in reliance on my right under the Fifth Amendment of the Constitution. I am not a lawyer, and I must rely on my lawyer's advice in this matter.
Yeah, so he's either a terrible doctor who can't even recognize dementia when it's slapping him in the face, or he's a liar. Maybe he's getting $4 million like the other dude was. But the inner circle admitted they interfered with this. Anita Dunn confirmed suspicions that the inner circle meddled with his health care in order to maintain political power, regardless of whether Joe even knew what was happening. Anita Dunn, she admitted to the committee that they had a discussion about whether he should have a cognitive exam. and they were talking about the politics of it. Would that address some of the attacks that Biden is getting? No, because the exam is going to show he doesn't have any cognitive function at all. That's Anita Dunn. Jeff Zients, also the chief of staff, corroborated Dunn's testimony. He said, yeah, we did talk about it. I do recall the communications team brought forward, led by Anita, whether he should have a cognitive test. And of course, they didn't do that. They deferred over to Dr. O'Connor. He didn't run the exam, and the cover-up continued. Other people also discussed healthcare. This guy, Bruce Reed, and they wanted to push back on this. The Inner Circle and their campaign to resist any medical examinations that may have hurt his chances were successful. It was not until the president's disastrous debate performance that anybody considered the need to examine his capabilities. Jeff Zients said this September 18, 25, recently. I do recall post-debate having a discussion with a doctor where I thought it was important for the president to get a full workup. In a response to that, and Dr. O'Connor took that on board. But inexplicably, his request appears to be the only and first time anyone ever brought this up at all. His testimony is that he heard Dr. O'Connor say, well, cognitive exams are meaningless, and so we don't need to run an exam on him. They don't even show anything. But none of the annual exam reports mention any form of any testing on Biden's brain because they didn't really need his brain to work. We all saw it. We saw him fall, trip, stumble, lose his train of thought repeatedly. We say, yeah, whatever. Or, anyways, I think he would say something, anyways, and just kind of move on to the next thing. You're like, dude, you're gone. They were present for the most recent falls. Karine Jean-Pierre covered the whole thing up. Here's this dude. And we're going to fast forward through a lot of the cognitive stuff. But there's a lot of it, you can see. Pages and pages. Yeah, here's the Easter Bunny attack. Less than 6 months after O'Connor said he was amazing, the American people witnessed a viral moment where the special assistant to the president, Megan Hayes, that's who was in there, the special assistant put on a costume. She interrupted the president and ushered him away from reporters in an attempt to avoid unscripted communications. Okay, let's see if this link works. One of my favorite links ever. Okay, let's cancel that. Let's open this in a new tab. This is such a good one.
The nest, I repeat. Take a listen to this or
Joe
watch
Biden
this.
got his heart.
Pakistan should not, and Afghanistan should be people.
Oh, the Easter Bunny, Mr. President.
Yeah, see that face right there? She almost gave him a heart attack. That was a special assistant to the president. Almost took out the president. Look at his face right there. Guys, look at him. He's petrified. He's like, this is it, man. Grim Reaper's here right in front of Joe. That was a special assistant to the president who was running interference. They put her in an Easter Bunny costume to go stop him from talking to the press. That was our White House. It's not funny. This is our country. They wrecked our country. So that is hilarious, right? And it was a special assistant. It wasn't just some random person. They're like, we can't go up there and like shoo him away from the press. We're going to look ridiculous. I know what to do. Put on a costume. No one will know. We all knew. Almost killed Joe. They were all meddling in this. They tried to conceal him from talking to the press. And the State of the Union was an anomaly. They probably, pumped him up full of methamphetamines or whatever, just regular amphetamines. Then, after the State of the Union, his performance, which displayed deterioration, confusion, was so shocking. Even Ron Klain explained during the debate, once the debate came down, man, it was a disaster. Ron Klain said something like, "We're effed." Hunter also said on a podcast that they gave Biden Ambien to be able to sleep, which resulted in him getting up on stage looking like a deer in headlights. Since Hunter made this allegation about unidentified people giving the former president Ambien, every White House or campaign employee interviewed denied Hunter's allegation. Yeah, that's interesting. Somebody just smuggling drugs to the president? Like, does the president just take non-prescribed drugs? that Hunter smuggles into the White House? Was the president on Ambien? Maybe that explained it. So obviously there's a cover-up, and the doctor's complicit in that. Anita Dunn also explains it. They wanted a full workup. Nobody wanted to talk about it. And now they're all invoking their Fifth Amendment. There was a major conspiracy to cover this up, and there were $8 million incentives. As we listened to Mike Donnellan, $8 million in order to get Biden elected. Strong financial incentives, and they became close over the years, and he wanted to get paid. So they just kind of, well, you know, he's good enough, right? $4 million, it's worth it. Donnellan and others were all controlling every step of this. The inner circle was also led by Ron Klain and had been there for a while, was so close to the Biden family that he later donated thousands of dollars to Hunter Biden's legal defense. Incredible. For his crackhead son. Klain provided the committee a clear example of how advisors screened information which made it to the president's desk. Mike Donnellan, a part of that. Question for Jeff Zients, Chief of Staff. Did you ever speak with Ms. Tomasini about any kind of physical accommodation so that Biden could get on the stage? She said, well, yeah, and so how do you reduce the number of steps? You know, things of that nature. Like just drive the car right up to the podium, you know? But so that has been reported on publicly, but Annie was the point for the president. And so she made sure he got his exercise sessions and all of the rest. Now, Biden was increasingly getting confused and disoriented, and age issues kept coming up. And they wanted to make sure he got appropriate reading time and family time and all of the things. Did discuss the age issues with Anthony Bernal, but the innermost circle of the Biden administration, all of it ran through the First Lady's office. Wow. Jeff Zients testified that Bernal thought through settings and frequency of interactions of the former president, and he thought that Bernal, who was on Jill's team, she played in making key decisions, were deeply concerning because Joe was losing his mental faculties. Example, September 20th at a cabinet meeting, the First Lady started the meeting in the West Wing by offering substantial remarks before the president's cabinet. She also was sitting on the Air Force One plane, prepping for the G7 in the president's suite on Air Force One. You're not the president, Jill. Doctor, the committee has extensive questions about Jill and Bernal and exactly who was doing what. They even went to Hollywood and got their professionals, Katzenberg and Spielberg, to help Joe figure out how to deliver the State of the Union. And throughout the presidency, they were just trying to make his job less difficult. Didn't want to answer many questions about it. Said he commented that the president flying from Italy to LA is a lot to ask. That's a big trip. Italy to LA? Man, how's he going to make that? Donnellan answering questions about that. They scripted a bunch of events. We watched it. They explained exactly where to walk. And ask this journo this question. This, hey, you do this. Then this happens here. Like paint by numbers for the idiot president that we had. Inner Circle and Communications also had a cover-up. Many people deeply involved. And a lot of this is kind of, repetitive a little bit. So we're fast forwarding through some of it. But all the details came out. Here you go. Yeah, here you go. Daily news summary. Remember these stupid cards that he had to walk around with? Why did you? Joe's like, you. Who is that? Is that me or is that you, the reporter? It's capitalized, so it's probably me. Why did you change your mind on the Hunter pardon? Well, he's targeted. And I believe in the justice system, but also believe politics infect. Why did you decide? When did you decide to do this? Won't this hurt your legacy? Like they had to just script everything out for the guy because his brain was completely fried. Then they kept lying to us. No, he's great. The Inner Circle used Ian Sams to also execute a scheme. Sams rarely interacted with Biden. Remember, he's that bald guy with glasses we've seen a lot of. He met with Joe, I think, twice. 4 meetings. That's all. Describing his meetings is very infrequent, but he went out every day. Oh, Joe Biden's great. He was the comms director. Then, of course, we got the Robert Hur report. Robert Hur came out, said, yeah, Joe Biden is an elderly man with a poor memory. Sympathetic, well-meaning elderly man with a poor memory. We all saw that. That was back in February 2024. Then Ian Sams came out and said, oh, it's gratuitous. This is completely inappropriate. Actually, Robert Hur was exactly right. And they smeared him as well. All but confirming his deterioration, the audio came out. President Biden couldn't even remember basic details like when his son passed away, when his term as VP concluded, why he had classified documents in the first place. They wanted the audio and they fought that forever. Then we got the audio and like, oh yeah, he's been gone for months. Then the cover-up happened as well. Many of them invoked the Fifth Amendment because they can't just say no. Here's this woman, Annie Tomasini. Mr. Bernal, question. Jill's work husband. Was Joe Biden fit to exercise the duties of the president? Fifth Amendment. Mr. Bernal, did any unelected official or family member of Joe execute the duties of the presidency? Fifth Amendment. Thank you. Here's one from Anthony Bernal, Jill's work husband. That's what he looks like. Dr. O'Connor, as mentioned earlier, pleaded the fifth as well. Ashley Williams, she stated she did not know, could not recall, or did not recall 200 times. Okay. I don't remember anything. Can't recall. These are the people who are running our country. All of them liars. Biden's senior staff were willing to conceal his deterioration because they wanted to win and they wanted money. Biden aides also testified, but none would admit that he was cognitively declined. So they're holding to their lies. Karine, not that I recall, everything's great. I never spoke to anybody about Biden's mental health, says Karine. Lots of just kind of standard questions there. There's Karine in her depositions. And this is a major document. Anita Dunn, some questions. Ron Klain, more from him. So it's a summary of all the interviews. Here's some more. Yeah. Did Biden have mental and cognitive health to serve as president? Does not, 65%. Yep. Does, not good numbers for them. They dismissed instances where Biden screwed up. They just said, oh, no, it's a stutter. Remember that? From Jake Tapper. All right, so I think you get the gist of this. A lot of details. There you go. There's a comment about the stutter. Biden's childhood stutter suddenly reappeared when his brain failed. Isn't that convenient? The cover-up persisted throughout 24. Many Americans thought he's not going to run again, but they had no choice. He then did decide to run again. Everybody went, what? 14 interviews all revealed that they all supported his reelection. They're going to work diligently and they're going to cover up his mental decline. Then they actually wanted to move the debate up. Remember? The earliest presidential debate in history. Because if it went on too long, then there was some thesis that they wanted Joe to fail and fall on his face now so they could sub Kamala in. Americans witnessed an incoherent debate. It was a disaster, and it was an epic one to watch. Biden's reelection campaign put the decline on full display. Then they had to nuke him and shove in Kamala without anybody voting for her at all. On June 27th, it was the debate. They scheduled the debate in a hurry because they wanted to conceal the truth. They said, we got to get him out now. Another 3 months go by, his brain's going to be totally fried. Age was became a surrogate for the cognitive and physical ailments. Why would an early debate change voters' view? Klain says, yes, I think it would. I think that his age became a bit of a surrogate for his capabilities to serve another 4 years. I thought that him performing robustly against Trump would show voters he had the fight and the feist to continue to serve. That didn't work out. Bad call there, Ron. More from Jeff. More from Steve Ricchetti. This person over here, Steve Ricchetti. And they remained on script for the debate. The debate happened. We all watched it, a crash and burn. Here's some of Joe Biden. 12 minutes and 15 seconds into the debate, Joe Biden came out and said, we beat Medicare. Remember that? Here's this one.
We'd be able to help make sure that all those things we need to do, child care, elder care, making sure that we continue to strengthen our health care system, making sure that we're able to make every single solitary person eligible for what I've been able to do with the with the COVID. Excuse me, with dealing with everything we have to do with. Look
at Trump.
If we finally beat Medicare.
Thank you, President Biden. President Trump?
Well, he's right. He did beat Medicare. He beat it to death, and he's destroying Medicare.
Hey, it's Joe Rogan. All right. So just amazing. He did beat Medicare. He beat it to death. I mean, he's terrible. So it's just great. So, all right. So that continues. And then they realized we're doomed. Because I thought the president's answer on that question had been halting, he had stopped in the middle and paused inexplicably and then had delivered that sentence that made no sense. And everybody went, oh, gosh, Joe's gone. Our president's gone. So they couldn't reconcile it. This guy is asked about it. We finally beat Medicare. What does that mean? Well, this guy goes on with some rambling answer. So, all right, this is the report. Joe Biden's brain is totally gone. A lot of people in the president's orbit confirming that. But here we go on the auto pen. Who was actually operating it? Following Kamala's decision not to enter the 2028 California governor's race, the New York Times highlighted Biden's mental decline. This piece, which is notably not in the opinion section of the newspaper, assumed the fact that Biden's acuity deteriorated before the American public. Senior aides interviewed were unwilling to acknowledge this, but our investigation shows his mental capabilities actually impacted his ability to be president. And the approval process for these pardons was ripe for exploitation. Bruce Reed said this: at times, I sat with Biden while he reviewed his decision book and decided whether to accept, reject, or amend recommendations. The president signed decision memos. They went back to the staff secretary, who was responsible for ensuring the decisions were documented. This practice is like the two prior administrations, where everything is memorialized. Now, however, additional testimony said that there were no processes for these. And Tandon only saw the president once every 6 to 8 weeks. So the people who would confirm with the president couldn't confirm with the president. There were no face-to-face meetings, unlike President Trump, who's right there. This is Trump getting handed the documents and signing it. Not a question about it. Here's another one from the president. Here's another one. But that didn't happen with Joe. It was all auto-penned out. Witness testimony indicates that the return journey for materials was similarly opaque. Documents would go out, then they'd come back. The White House's decision-making procedures were so lax that the chain of custody for a given decision is difficult or impossible to establish. Perfect. Documents that were used to predicate executive actions should be sufficiently traceable to ensure they reflect the will of the president. I mean, like your mortgage documents, are recorded. Instead, the Biden White House and their flimsy procedure was extremely vulnerable to abuse. And much like the processes for ascertaining the decision on executive actions, same with the auto pen, the use of a device that replicates Biden's signature should be documented very clearly, but they didn't do that. Tandon oversaw the use of the auto pen, but did not physically operate it. She explained that she would inform the White House clerk called David, and then he would have his staff actually auto pen the document. Who? Said, did you ever personally witness the auto pen use? No, not until late in my tenure. Do you know who the people who actually operated the auto pen were? Do you even know who they were? No, I don't. Great. Did your office track the documents that were signed by the auto pen? No, they did not. Now, a recently uncovered document indicates that there may have been a specific set of guidelines that should have governed this, but apparently it wasn't actually followed. Here was a memo that was apparently published February X 21. And it does denote, it says you have to hand sign pardon letters right there. And we covered this some time ago when that document came out. John Solomon reported it. And we said, yeah, you actually have to sign it. He didn't. They auto-penned it. His own administration was saying sign it by hand. He didn't. Now, the presidential pardon game of telephone, as we talked about here, reveals that some decisions were dubiously authorized To your recollection, Ron Klain, were there any situations where you didn't use this formal process? Yeah. There were times when Biden made decisions orally, where we'd have members of the cabinet in the room and he would say, I would just do this. Okay, after he said that, would you document it since you're the chief of staff? I think there were times that we did, and there were times where we didn't. I remember a couple. Well, I remember one specifically was the decision to have a vaccine mandate for the armed forces, where Secretary Austin came in and explained, I want to do this. Because remember, Lloyd Austin was the double face masker, face shielder. And so he just said, yeah, go ahead and do it. So there were verbal authorizations, but recently uncovered documents and testimony also indicates that even when a verbal decision was memorialized in an email, it doesn't prove that Biden made the decision. It's just somebody else saying that he did. Here's this one from Jeff Zients, January 19th, one day before Trump comes in. I approve the use of the auto pen for the execution of the following pardons. Thanks, Jay-Z. All for the president's fam. Now, he said, even Zients, who approved this, oh, so you were at the meeting with Joe? No, he didn't even attend the meeting. He wasn't there physically or virtually, during which time Joe allegedly said, I approve the pardons. In fact, Rosa, the staff member who actually sent that email, also did not attend the meeting. According to Zients, the game of telephone went as follows. So here's how it went down. Bruce Reed, Ed Siskel, and others went to a meeting with Biden on the 19th to discuss the pardons. Then others, Reed and Siskel, walked back from the meeting and told Rosa Poe. Then Poe called Zients at his home and said, here's what happened inside the meeting. Then no one called the president. Zients sends an email saying, I approve this. Poe sends an email on Zients' behalf, approving the use of the auto pen. And then somebody somewhere signs the actual pardons with the auto pen. It's like a joke. While it seems no pardon should be authorized through this ridiculous game, it's worth noting that this included some of the most controversial pardons that exist. Biden's family members, criminals. Anthony Fauci, criminal. Mark Milley, criminal. And the January 6th Select Committee members, criminals. All of them got pardons because they committed crimes. And who knows if they're even valid. So they discovered a bunch of other anomalies. Remember, 2,500 people also got commutations. And the question was, who was doing the vetting on any of these individuals before it landed on Joe's desk? No one really knows. So the report is now out. Biden also pardoned Hunter before that. He said, I would not do that. And then he did. And I think he signed that one by hand. Then they educated him on how to respond to this. He granted more pardons and more clemency than anyone else. And apparently had no ability to do it. All of this subject to abuse. And in conclusion, this new report that invalidates Biden's pardons and would encourage the DOJ to do something about it, which they are, they write, faced with this, they hid the truth. The inner circle propped him up for his entire term. They kept him in the race despite knowing he was no longer fully in command. And shockingly, as addressed in this report to this day, over 1 year after the race, all of his people continue to deny their scam. The scripted rhetoric of the cover-up is so ingrained in White House staff that even Robert Garcia, this guy, attempts to maintain this illusion as he says Trump is the one who's losing his faculties. Now, Democrats, they only bothered to ask approximately 3 hours and 30 minutes worth of questions in this entire process. We had 47 hours of depositions. Democrats asked 3 hours and 30 minutes of it. When averaged across 14 interviews, they were asking 15 minutes of questions because they knew, everyone knew. But they just wanted Joe to win. Now, the cost of the scheme to hide the fallout diminished that what happened will never fully be calculated. The cover-up put our national security at risk. And no one even knows if Joe was in charge, which, may be responsible for a lot of the damage that was done, but it's his administration. White House aides were instrumental to the cover-up. Dr. O'Connor is deeply disturbing. He won't even answer basic questions about whether he falsified his health records. So, barring evidence of executive actions taken during Joe's presidency that show that he actually did take an action, we deem those actions that are taken through the use of the auto pen, including the pardons, as void, not valid. The validity of the actions allegedly approved and signed by the auto pen must be reviewed to determine whether legal action is necessary to ameliorate the consequences of any illegitimate pardons granted, any illegitimate executive actions implemented throughout the auto pen presidency. The committee finds numerous actions, especially the clemency actions, as illegitimate. Therefore, we urge the DOJ to investigate all of these actions attributed to President, allegedly, Joe Biden, signed by the Oversight Committee in a major report that is showing how corrupt these people ultimately are. And here is more from this video over from Ron Klain. We left off right around this time, and here are some more highlights from the report.
Tell you that you will have the same answer with respect to any questions that are asked.
Did any unelected official or family member of President Joe Biden execute the duties of the presidency? Did Joe Biden, a member of his family, or anyone at the White House ever instruct you to lie regarding his health?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights.
Oh.
And if that
Would you say that you interacted with the president in person?
I interacted with him pretty infrequently. I think I met with the president a handful of times during my tenure in the White House.
I gotta say, that doesn't look anything like the president that I know. When I deal with him, he's sharp, he's asking tough questions.
Wow.
That's the President Biden that so many of us experience every single day.
You don't think it's missing some context?
I don't.
So it raises serious concerns and serious questions about who was calling the shots in the White House. If the White House spokesperson is being shielded from the President of the United States, who was operating the Oval Office?
That night during the debate?
I do believe that he was fully in command that night during the debate.
I knew it was very difficult to get past some of the visual things that were causing people concern about the president's budget.
The voters' concerns about President Biden were wrong?
Yes. He often would confuse names.
Do you think it got worse as you knew him?
Yes.
Are you sure you're being honest with yourself when you say you have the mental and physical capacity to serve another 4 years?
Yes, I am.
I did not have the experience that it took him longer to answer a simple question.
He could stumble. He also stumbled some physically.
What is it you think?
It was something that we did not coin. It was something that the media coined.
Did you or did anyone ever verify if the videos you were talking about were, in fact, cheap fakes?
I believe so.
But there were instances where videos were circulated of President Biden appearing confused or freezing for a moment that were real, correct?
Not that I recall.
She told you this real video of Biden getting lost in an Italian field was fake. Now she's saying, yeah, my White House was broken and I'm switching parties.
And was suffering from a cold that really constrained his voice and constrained his ability to be forceful in the debate.
Do you attribute President Biden's performance that night to him being under the weather?
That's my assumption.
The ability of Medicare for us to be able to negotiate drug prices with the big pharma companies.
Had you ever seen him have a cold or the flu before?
Yes.
Did he ever behave the way that he did during the debate?
Not that I ever saw.
of the United States.
Do you know who the people who were actually operated the auto pen were?
I do not.
No one
Do you
knows.
know any of the actual staff who were using the auto pen?
Who is it?
No,
You don't know their names.
no.
Have you never seen a decision memo laying out the breakdown of when the president should hand sign a particular set of documents?
Not prior to prep.
Did he hand sign all executive orders?
He did not. He hand signed many executive orders, but he did not hand sign all executive orders.
Can you read your response?
I approve the use of the auto pen for the execution of all the following pardons. Thanks, Jay-Z.
Did you yourself write this email?
I do not believe I did.
That
Liars and criminals. And now, good evidence that their pardons are invalid, null and void. And Pam Bondi has now caught the ball. We'll see what she does with it. But prosecutions should be underway if there was an abuse of office, an abuse of process, an abuse of presidential power that is illegitimate. Executive actions should be rescinded and voided. Maybe Republicans will take that into court. Maybe Trump will make that argument about some of the powers that they're claiming in their lawsuits. And the pardons should be deemed null and void. And the people responsible for the crimes that those pardons were covering up should be prosecuted accordingly. And they can bring in evidence to support their claims that the pardons are valid. But without any evidence to support that, they're just garbage pieces of paper that were signed by some unknown person with an auto pen. So a very nice report from the Oversight Committee. Of course, we're going to keep our eye on this one. Hopefully it is cracking the shell of the Biden administration's crimes and cover-up so that we can get to the bottom of this. We'll keep our eyes on it, my friends. Thank you for subscribing and joining as we do. All right, my friends, what a beautiful stream that is. We covered a lot of ground. Couple hundred pages there. We didn't read it all, but mostly. So we understand what's happening out there. If you're just joining us, quick recap. 2 documents we covered today. Massive appeal for President Trump in his criminal case. Of course, 34 felony convictions, and now taking that up on appeal. And this was a very nice brief explaining all of the problems with the case, the corrupt judge, the perversion of the law, federal preemption, presidential immunity, the pick a crime, any crime, and why the judge was so biased and partial that he should have never presided over the case to begin with. Great stuff. We'll see what what the Bragg DA says in response when they file their response, and then Trump will hit him with a reply, and we'll keep our eye on this one. Then we talked about the auto pen presidency and the fact that Pam Bondi has now received the report over from Oversight, and Oversight is saying Biden's executive actions are null and void. And we're excited about that. Hit the highlights of this report, another very big one, 100 pages, going through dozens of hours of depositions and showing just how corrupt and criminal all these people are and how they put a Biden aide, a special assistant, in the Easter Bunny to prevent Joe from talking to the press and almost killing him in the process. But now, my friends, it's time to hear from you. Happy Tuesday. Thank you for joining us and for being here today. And thank you for these nice donos that came coming in here. And let's see what you guys have to say about all this. It is a lovely Tuesday. Hopefully you're out there accomplishing all the things you set your mind to. And here's what we've got today. We're in the wrong chat over here. That is my bad. So we're over here. Let's see what we got cooking over here. And we are, what did I do with our dono chat? Here it is. Amazing. All right. So your boy was a little discombobulated this morning, right now. But let's see what we got. I saw a great one from our friends over here. What's this one? Yes, from Ravicus. Did we get these one in here today? Yeah. All right. So here, we're backing up. Here we are. It's Happy Tuesday. All right. My apologies. It took me a minute. I am here to wish you Happy Tuesday. Look at this little kitten. What an adorable little kitten. Well, Happy Tuesday to you, little fella. Thanks for coming and saying hello to us. Hey, K-Bean, please read the mod Telegram chat. I read it, K-Bean, and we'll do that. I'll take care of that after the show. Thank you for the heads up on it. Trinal Galaxy. Hey, afternoon, Rob. Did you see Trump use the video game Halo to support ICE on X? Leftist gamers are completely angry over that. From Trinal Galaxy. I think I did see that. It was Trump with the Halo sword. I remember that game. I didn't play a lot of it because I think I was pretty terrible at it. I'm not a very good video gamer. And I like play with my friends and they like kill me like 100,000 times in 2 minutes. I'm like, what are we doing here? I think it was one of those games that I kind of missed out on because everybody got really good at it and then I never played it. I was more of like a Command and Conquer guy myself. But Trino Galaxy, what a great comment. Shout out to Trump, continuing to troll the left. They hate it. Cardinal O'Flanagan. I'm curious. So where's the charges over the Hunter Biden laptop known cover up after the election? Alan just forgot about that. Or which one's Alan? Yeah. Are you talking about the 51 laptop letter? Those people? Yeah, I would agree with you on that. There should be a thorough investigation into that and how they abuse their positions. And maybe the CIA can do something about that now that Ratcliffe is in there. But yeah, I mean, if anybody's pardon is valid, it might be Hunter's. I think that one was hand signed by Joe. Hey, Jacob Castro. Thank you for rating our stream over there, Jacob Castro. Shout out to all of our Jacob Castro friends in the house. Very nice to see you. Thanks for coming over. Off-Label Podcast is here right next door on all the tubes. Says Ohio uncovered over 1,000 non-citizens registered to vote. I thought that was illegal. How is that possible? Some with voting history. DOJ has sent the case for prosecution. Man, that's good. Off-Label Podcast. I did not see this story, but that's why you have to watch Off-Label Podcast right next door to get all the details. Hey, what's up, Nate Bartow? Says disgusting and pathetic. So sorry, so sad. I don't know if you're talking about me, Nate, or the stories we covered today, but either way, it's a true comment. It's true. So thanks for that, Nate. We appreciate you being here. What's up, Andrew Benton? Welcome to our latest supporter, Andrew. If you're a YouTube member, we'll see you in the after party. We'll hang out. We'll debrief and say what's up to our members. Also, we had a members only morning stream this morning. It was a good one. Jeffrey Adams, are you aware that the Utah furry has gone missing? Yeah, the lover of Tyler Robinson, yeah, is apparently MIA. I saw that. I saw like his house is boarded up. Everything's gone. He's gone. Nobody knows where he is. Which, you know, makes sense because we haven't seen Tyler Robinson in a month as well. So everybody's just under witness protection or something, says Muffin Rando. FD Man. This is from Tropic Thunder from Bragg, from Tropic Thunder. I'm a dude playing a dude disguised as another dude from Tropic Thunder. Is that when he dresses up as the Iron Man, dresses up as a black man, right? This is the misdemeanor playing a misdemeanor disguised as another felony. It's very confusing. Yeah, works much better in a comedy movie rather than in a court of law. But the Mercon courtroom was basically a clown show, so it also works. Sheila the Pooh, 1,000,000 hugs to you. Thank you, Sheila, for bringing in 10 new membos. Hopefully we see you in the after party coming up soon. Michael L. is here. Simply Rose in the house. Jay Liebgott, what's up? Maha Rushi. We got Joe Dokes. What's up, some dude? Eric Johnson. We got Daniel Hobbs, Polyphos, and Boots O'Halloran. What's up, Boots? Welcome, GA Mint Girl, also in the house, courtesy of Sheila Poo. A million hugs to you. Thank you, Sheila, for bringing in new membos in the house. FD Man, what's up, FD Man, over on Rumble? Thanks for watching over there. Says, the Federal Workers Union and now the banking lobby is applying pressure on Senate Democrats to vote on invoking cloture to pass the CR. Dems are not in a good spot. I didn't see the banking lobby. We talked about the Federal Union, I think last week, maybe on Friday when they came out. But yeah, we'll see if they start to buckle, and all the SNAP benefits are expiring November 1, apparently. So there's going to be a lot of pressure percolating out there. Hey, what's going on? Ravicus with a couple of comments. Thank you, Ravicus. Seems like it would fall into conspiracy field to me. Would that be a RICO case then? And possibly money exchanging hands from people buying pardons? Yeah, RICO, I mean, like, you can have a racketeering case, which is really what that is, but you can have a conspiracy without it being a racketeering case. So, RICOs involve conspiracies because it's racketeering and across a big organization, which necessarily involves a conspiracy, but a conspiracy doesn't have to involve, a RICO case. Like, you can charge just a couple people with conspiracy. I'm sorry, guys, if I'm asking dumb questions. Everything I learned was on the back of a cereal box. Yeah, me too. I read a lot of cereal boxes and a lot of placemats coming up. The placemats with like the states and the capitals on them and like all the things. Yeah, a lot of those. So Ravicus, not a dumb question. Good question. What's up? Trino Galaxy. Hey, the Dems and especially Jill Biden should be prosecuted for elder abuse. Yeah, they insist on keeping people in power for their own gain, no matter the cost. Yeah, and it was like elder abuse in, 2020. We watched it. They just kept abusing the dude. He's falling over sandbags, the whole thing. Trino Galaxy, it's right. If you took your demented grandmother into the bank and had her sign some documents for you, you'd be charged with elder abuse and exploitation of a vulnerable adult. But if you do that to the president of the United States, you get an executive order passed. No big deal. John Allen, what's up? Hey, thank you, John, for this nice dono and congrats. Rob, I want to congratulate you and Alexis on your marriage. You both are amazing people. I know that God will bless you both in your lives together and when the time comes with beautiful, wonderful children. You definitely bless us for many years and deserve all the best in life. Love you, brother. By the way, this is to offset those wedding expenses. Oof, LOL. Yeah, it's true. Our wedding was beautiful, and it should have been because we spent billions and billions of dollars on the wedding. So thank you for that, John Allen. It was very good. You definitely bless us. Thank you, John, for being a part of our community, for the nice comments, and for the well wishes. I hope that you enjoy the same and have a beautiful life indeed as well. Thank you, John, for the nice dono. FD Man, who believes that the deeply, openly closeted, biracial, homosexual man who married his college boyfriend named Barry was in charge of the auto pen? I do. Who is that? Is that one dude? I don't know who that is, but sounds plausible. FD Man, look at the worry on his face. It ain't because of what he is saying. It's because Hillary may be sending some cleaners as the dominoes begin to fall. Oh, gosh. Hillary and the Clintons apparently have killed a lot of people, so hopefully they don't kill any more. FD Man, thank you for the donos, my man. G-Gum, what's up, G-Gum? Says, the Alina Hi Rob. Yeah, Alina. I remember we used to have Alina Abba in the house. Then I found a very nice woman and had to stop saying that. Is now officially replaced. I'm not going to make the Bye Rob version because Alexis and Rob are going to stay together forever. Whoa, a little Hi Rob from my beautiful wife. Yeah, she's so smoking. Isn't she a babe? Thank you for that, G-Gum. What a nice comment. I can't wait to show her that after the show. Thank you for that, G-Gum. Meme Smith extraordinaire. Hi, Rob. Good to see you, my love. Hey, what's up? Jedi Trump is here. Bringing in 5 more membos. Jedi Trump. Mike Moran, welcome. Alborz Chalabi in the house. Paul Rounds joining us. Kat Randall in the house. Angie G, all gifted membos, courtesy of Jedi Trump. These are not the narco terrorist that you're looking for or something. And then he blows him out of the water. All right, what's up? Hey, it's Tony Hay Munkets in the house. Thank you, Tony Hay. Bringing in 5 new membos. Reckless, welcome. Q Revere. We got Carl Swelling, PK from AK, and Lizzie B. All gifted membos in the house. Another one from Nate. What's up, Nate Bartow? Nate says, poor Bunny. Does she make as much money as you? I'm not even sure who you're talking about. Nate Bartow? Are you talking about Jill Biden? I think she's probably stolen a lot more than I ever have. Jay Marino, which is 0. Jay Marino says the fact that no attempt was made to obscure intentional prosecutorial and judicial misconduct to convict Trump exposed the absolute corruption of our judicial system. Make up any law, ignore any rule to get the desired result. The scary part is that no authority or institution objected. The entire judiciary, federal, state, destroyed their own legitimacy. Once a Vestal virgin gets caught in bed, it's over forever. Yeah, I guess that's an analogy to use. Yeah, I agree. I think that they wrecked, FBI wrecked itself, DOJ wrecked itself, CIA wrecked itself. They shouldn't have been partisan hacks, and maybe they'd have some credibility. This old guy, as much as it pains me to say it, I have to come to Biden's defense. He's really the victim here. His staff is evil and should be on trial for elder abuse. What a sorry bunch of self-possessed jerks. Yeah, I mean, I have some sympathy with that. You know, ultimately, Joe Biden, I would imagine, had moments of lucidity, and he should have had the mental faculty to pull himself out of the equation. But yeah, he probably had a bunch of people. You're fine. You're good to go. This is normal. You know, other presidents have aged in office and whatever. And, you know, if you're an elderly person with dementia, yeah, you know, you're like, that's the thing with dementia. Like, you're losing your faculties. You're losing your volitional activity. Like, you can't be really responsible for what you're doing because your brain is fried, you know? And there is some of that with Joe. Now, at the same time, he also was lucid enough to get on the stage, get on the debate stage, and get out there and scream, gates of hell, take your vaccines, and all the things. So it's like, in those moments, he should have had the better judgment to just nuke himself from the campaign, and he didn't. Nate, what's up, Nate? POTUS says, POTUS, 2 unfit vegetables. MAGA cost lives, no good. 5150. Yeah. Yeah, nobody really knows what you're saying there, Nate, but we appreciate the donos. Darren says, I don't really understand. Can you make another donation and explain? So I think you're calling Trump a vegetable. MAGA cost lives, no good. 5150. Okay. So thank you, Nate, for the dono. We appreciate that. We'll use that to support our show, to continue to support the Trump administration. Off-label podcast. I wonder if these executive orders were signed with an auto pen. If so, it means the government can't register you to vote anymore, and we are not on a CBDC then. From Off-Label Podcast, more details on that analysis on their channel. Doan, Obama ripped Pelosi a new one for backing Kamala. I heard that. I heard that he gave her a call. It was very unhappy about that. Because I think Joe shoved Kamala in. Like, when they set Joe aside, remember Joe came out, he's like, well, Kamala is going to be my number 2. And I think they would have been better served with an open primary, like a really compressed primary, but by Joe endorsing Kamala, that kind of took that off the field. And I'm sure Obama was not happy about that. Zone Girl, what's up, Zone Girl? Jill Biden can write her book. I was the first woman president in history. She was the will and pusher of status. Dr. Jill Biden, the first female president. She thought of herself as that, but she'll never be the president. Hey, thus we stand. Thank you for gifting membos over on the Rumbles. We got Dog Digger, Donut Mind Me, Jacob Castro, Mexican Trumper is here, and Nana Bear 007. Gifted membos, courtesy of Thus We Stand. Thank you, Thus We Stand, for doing that over on the Rumbles. FD Man says, the Biden administration, the ultra pseudo constitutional executive branch, ultra pseudo constitutional executive branch, 21 to 2025, diabolical. It was just an empty presidency taken over by the worst of the worst. We don't even know who. DC Metro. Thank you, DC. Very nice dono in the house. No comment on that, but we appreciate you supporting us here today. And that is the DC Metro, isn't it? Yep. FD Man. I am one old guy's opinions Oh, okay. Congratulations, Rob. May you and your lovely bride have many long years of love and happiness through the good times and the bad. And may your first child be a masculine one. I hope so too. You know, coming out with like biceps already, you know? Hey, Benjamin Brantley, good stream, Rob. Did you see the Chicago judge ordered Bovino to have daily meetings on ICE operations and no tear gas on Halloween? I didn't see that one specifically. I saw another judge, I think from California today, said that Trump can't fire anybody during the shutdowns. And yeah, a lot of stuff. This morning on the members only stream, Benjamin, you're a member. Thank you for that. We did talk about ICE, and there's major firings happening, or not firings, removals. They're demoting people in senior positions from ICE and replacing them with Border Patrol people and wanting to increase the deportation pace. So good stuff over there. But I did not see that with Bovino. So they're going to try to bog him down essentially so that he has to have conversations with these people constantly and can't do anything productive. Nice. Rick D. Hey, just realized seeing a video of Hugh Jackman that without the beard and mustache, Rob is like Hugh's younger brother. Wolverine? Man, that's a nice compliment. I don't think I see it, you know, but thank you for that, Rick D. Hope your knee's doing well and you can get back out of those airplanes any moment now. Yeah, Hugh Jackman, I remember. Wolverine. Those are good, you know, he's jacked, whatever he was taking. FD Man, the last part of the Godfather wedding scene says, from FD Man, says you can't fault them for what they did with Joe. They kept cackling comrade Kamala out of the Oval Office. Could you imagine? No. No. I think we'd all be in gulags right now. RP Games, 20 membos from the RP Games in the house. Good to see you, Keys Cook. What's up? Null Hypothesis. Jack Craig is here. Dimes A Granny. Daisy May Granny in the house. Sorry about that, Daisy May. Nicholas McCoy, what's up, Rusty Brats? Bev Red Wave 24 in the house. B Katrina. We got Black Kiss. B Dub is here. Ken Kraus, what's up? Muffin Rando, good to see you. Evan Huff, Robert Johnson, Kevin Myers, Paul D, Charlie Flaw, Blake O'Brien, Craig Power, Doc Brining in the house, Rohan, Luan, Tom Ragoins, and the RP Games. What's up, RP? Thank you for that. I was blessed, so I bless others. What a nice thing. Thanks for paying it forward, RP Games. For being a membo, welcome new membos. We'll see you for the after party. Hey, Ospac is here. Great show, Mr. Alexis Gouveia. It's got a nice ring to it. Welcome back. Good to see you, Ospac. Thanks for that comment. Yeah, that's a fun one. FD Man, Dr. Jill's first female press with the glass ceiling being Kamala's what? Starfish? I don't even know what that means, but I can guess, and it's probably not good. All right, so my friends, thank you so much for those donos. Welcome to our new membos. Kamala has a starfish, like as a pet or something. Hey, B Torn, couple of great comments over on X. Here, this one looks like you had a great wedding, Robert. Is this a picture from our wedding? I don't remember that. I don't remember the manatee being there, but is that a manatee? What? I don't think it's a manatee. What is that? What the hell is that animal? Is that a seal or something? I don't know, but he looks nice. Wish I would have invited him to our wedding. Satellite Boy, what's up? Good to see you on Rumble. Guernica. Here's one from Guernica. Says, how can a defendant form a defense against if they've never been apprised of the charge? We think you're guilty. Guilty of what? Whatever we say. It's not justice in America. It's completely ridiculous. Feline Fun, what's up? Says, last summer when all those indictments came down, it was such a discouraging period. Trump has been to hell and back. I truly believe he's anointed by God. What a wild journey it's been. Yeah, I mean, there's, I'd say, a lot of divine intervention, especially when a bullet misses his brain by about a millimeter. Pretty wild times. Satellite Boy. Yeah, David Pecker and Anthony Blinken. The whole thing completely rigged. Thank you, Satellite Boy, for the dono over there on X. B Torn says, you like Command and Conquer? Yeah, remember when Gina Carano was, never mind, you're married now. She was in Command and Conquer? That was Gina Carano? I did not know that. That's hilarious. Yeah, great game. Yeah, great game. But it fell off. Why did it fall off? I don't know. They should have just kept it going in the original version. It was so good. All right, so my friends, We will leave it there. Hey, Rick D's jumping out of airplanes again. Already jumped again, Rob. Jumped like 12 days after it happened with a group from Knoxville. Rick D like blew out his knee, apparently. And then 11 days later, flying out of airplanes again. Man, that's dedication. Glad you're back. Glad you're back. Not on your feet. Glad you're back in the sky, I guess. So, my friends, thank you for those great donos. Thank you for supporting our work. We couldn't do it without you. Very much appreciate you subscribing to our channel. If you haven't already done that, and if your fingers work, we'd appreciate a little press of that like button so that this show can reach more people who hopefully will come and join us. We also appreciate you sharing it with friends or family members so that they can come over and join us and partake in just the tremendous fun that we have here. And we appreciate you coming back tomorrow because we're going to get into it again. Before we wrap it up on the day, big thanks to our amazing mods and meme smiths. Of course, today, Donut Mind Me, John clipping away for us, K-Bean, Carrie B, always helping out. Think we're going to be adding a new mod called Muffin Rando very soon, so we'll get that done soon. And we appreciate welcoming Muffin Rando into the crew. We also want to thank Neuro D, Janek, Dog Digger over on the Rumbles, holding the fort down. Our friends Gigum Gigum with the new meme of my beautiful wife and bride. And our friends Elliot and Just Rhonda, all helping out around here. Grateful for everybody who makes this possible and appreciate you being here. Of course, we're coming back tomorrow. It's after party time in just a few minutes, so stick around if you want to join us. We'll keep it brief and say what's up, but we'll see you back over there. Otherwise, we're coming back tomorrow. It's going to be Wednesday already. We're going to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care.